Is that there is some urgency in the matter. This talk Friday.
Monday,
20.
have an interim order. Monday.
Can I fix it on Monday?
I have no objections.
Monday?
Subject to what my learned friend said.
Oh, okay. Because the court master is
Yes.
warning me. 29th.
Madam, we have an interim prayer. Kindly ignore it.
Okay. Interim order passed today, stands extended till the next date of this team.
I'm highly obliged. Highly obliged.
May it please, my lords. My lord, I beg to mention item number 1 and 2. We
Yes.
have submitted an adjournment script, my lord. My lord, Mr. P.N. Goswami is out of station due to certain health checkup. My lord, I pray that the matter may be taken up after 2 weeks, my lord.
Okay.
My lord, I appear on behalf of the petitioner. My lord, I say interim order. My lord.
Okay. This after 2 weeks as per for by Mr. A. Barwar and council appearing on behalf of Mr. P.N. P.N. Goswami. Additional Advocate General for the respondents. Interim order passed today, stands extended till the next date of this team.
I'm obliged. May it please, your lord.
Yes.
So that's why listing of matter for the admission.
Which year?
22.
22. Okay. Give it to the court master.
Similar prayer also.
Which year?
22 year lordship.
Give it to the court master. He will have to make. He may have to make some adjustments 1 day or 2.
Lordship,
Yes.
I would like to mention item number 19 for adjournment. My senior won't be able to take up the matter due to sudden demise of his uncle. So the interim order passed earlier be continued till next day, and the matter may be listed after 10 days.
Okay. Both sides are represented. It is submitted that the council holding the brief is in bereavement on death of his uncle. Accordingly, matter stands adjourned today, just after 10 days. Interim order passed today, stands extended till the next date of this time. Item 19, you said?
Item 19.
Okay.
Yes. Supplementary ordinance item number 23 to 25 to the spoken page.
This matter, I have to take a small re-hearing because it has been a long time. We'll take it up at about 3:30 today.
Yes, sir. This perhaps is not the he appeared for the
Forest department.
I think basically we need your Mr. Goswami or demonstrated from the Amtron people that the site was not opening. Oh, sorry, the documents were not
sign.
filed in the PDF format. It did not have a digital signature. Apart from that, I don't think he's any submission. Because it's a long time, so I'll try to conclude it today. 3:30. We'll take it up.
Obliged.
26 for Mossad.
May the lordship, my lord, the lordship permission. My lord, with the cost of repetition, my lord, I take your lordship to the impugn order again, my lord. Page 56.
It's okay. I remember your argument.
My argument is here, my lord, maybe I was wrong in placing my case. My lord, the register has said that he has observed that the observer was there. But he has not called the observer. Observer was not present in the meeting. While
Where
hearing
is that? Where is that?
my lord, your lordship at page 56.
56.
Heard the petitioner and the respondents. We are the respondents, page 56. Peruse the documents are submitted. It is found that the observer report of such and such Pujai first meeting was conducted in the presence of 8 newly elected who unanimously selected such and such president, chairman of such and such, which according to the petitioner was not a fact but a manipulated report of some vested interests. But those observer was not called, the witnesses were not called, the peon book was not seen, and he passed an order, only saying that it's a manipulation.
Yesterday you said that he was present.
But he was not present, he was not called.
Yes.
Lordship, may kindly have a look, page 57, once again, the type copy of the order, my lord.
Yes.
The third line from above, my lord. No authentic and convincing proof regarding holding of first board of director meeting for selection of the president and vice president with prior information to all the newly elected members of the so and so Samabais Limited could be produced by the respondent at the time of the hearing. Therefore, the board of directors of the so and so limited is hereby directed to hold afresh the meeting for the selection of the president and the vice president with prior permission to all the newly elected members of the so and so Samabais Limited. Hojai is requested to take necessary action in this regard, my lord. There is nothing informative.
Then what happens to that report of the observer?
My
He
lord,
was present in the first meeting.
My lord,
So what would happen to that?
that regarding the lordship, I'll get instruction, my lord.
till then, my lord, the input order may be stayed now.
This has to be stayed.
Lordship will fix the matter next week.
No, you see, there are reasons to do that. Number one, you'll have to produce us a notice
My lord,
that he was required to produce all the original documents,
my lord.
correct? Now authenticate proof, correct? He says, no authentic and convincing proof.
My lord.
Now, what would that mean?
Yes,
Today,
lordship.
suppose
Correct.
you are the lawyer for the petitioner.
My lord.
I say that your petition I have read. I don't find any convincing proof when I dismiss it. How do you like it?
Otherwise, lordship may, their prayer also, he says, page 15, my lord, to rehearing the matter. Lordship
Yes,
may
my lord.
direct that also, my lord.
You get the instructions. If you want, we'll take it up next week.
Yes, my lordship may dispose of the matter. with the-
You are consenting.
Yes, my lord.
Okay.
Lordship fix the matter next week. I will get written instruction.
No, both things can happen.
My
Number
lord.
one,
My lord.
we can record your statement and we can close it. Or if you want that, we fix it on the next week, you get instructions. You can do that both, whatever you want.
Written instruction is convenient for me also. But if my lord may direct them to rehear the matter, I have no objection.
My lord,
Then I'll
then
record that and I'll close it.
my lord,
then
this
why
order
keep it
has to be
pending?
set aside, my lord. Then-
Why should I keep it pending then?
Yes, my lord.
Okay. Heard. Mr. P.K. Roy Choudhury, learned counsel for the petitioner, and Ms. M.D. Vora, learned
Standing on
standing counsel for the Cooperation Department,
my lord.
appearing for respondent numbers 1, 2, 4, 3. 1, 2, and 3. Next level.
Private respondents are there, my lord. Their
Uh,
complaint was there.
Oh, that will be a problem.
Then, my lord.
Without hearing them, I can't
Next
dispose of the
party, we cannot-
petition.
Yes, so many private respondents are there, my lord.
Okay, then I will dispose it of. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the order dated 28/4/2023. Give the number also, page 56, number GPSS 54/2020-255. 28/4, passed by the Registrar of Cooperative Societies, Assam. By the said order, on a perusal of the complaint made by the private respondent numbers. Yes, numbers 5 to
4 to 13, my lord.
5 to 13.
5 to 13, no, 4 to 13. 4 is secretary, we have to take. 4 to secretary, whether my friend will take copy for 4 or we have to send registered post.
No, registered post.
Except on behalf of private respondent.
No, secretary.
Secretary,
You can accept.
my lord.
Okay, then make it 1 to 4. Okay. Private respondents arrived at a conclusion that the persons lodging the complaint were not informed about the meeting, and that no authentic and convincing proof regarding holding of the first board of directors meeting for selection of president and vice president was available and that those documents could not be produced by the petitioner at the time of hearing. And accordingly, the said authority directed that a fresh meeting for selection of president and vice president of NAKHUTI, NAKHUTI SS Limited be held. And the Assistant Registrar of Cooperative Societies, Hojai, was requested to take necessary action in this regard. Just make it to ACRS, Assistant Registrar of Cooperative Society, and the Secretary, NAKHUTI Samavai Smriti Limited, within bracket respondent number 4. We're directed to take necessary action in this regard. And the approval of appointment of the petitioner as president, public chairman, and one Siddiq Ali as vice chairman, and the order of the Assistant Registrar of Cooperative Societies, Hojai, giving approval to the said meeting was set aside. Next paragraph. Issue notice of motion returnable on so and so. Requisite extra copies of the petition is served on the learned departmental answer in course of the day. First of the petitioner shall take steps for service of notice on the respondent numbers 5 to 13 by registered post with AD. And in addition, the petitioner is at liberty to serve notice on said respondents by thusly by routing the process through the registry of court and to file affidavit of service prior to the next date of listing. Next paragraph. Heard both sides on the prayer for interim relief. The learned counsel for the petitioner has been able to demonstrate that on 29/7/2022, the Assistant Registrar of Cooperative Societies, Hojai, had appointed Sri Tapan Kumar Das, Junior Inspector, Public Auditor, Cooperative Societies, Hojai, as departmental observer. And on the same day, i.e. 29/7/2022, notices were issued to the members of the board of directors and in the said notice, it has been mentioned that with the approval of the Assistant Registrar of Cooperative Societies, Hojai, dated 29/7/2022, the first meeting of the newly constituted board of directors would be held on 30/7/2022 at 1 p.m. So it is also demonstrated that as per the peon book, few of the notices were served, whereas few of the notices could not be served as the acceptance was refused. In the meeting held on 30/7/2022, the petitioner was elected as the chairman and thereafter on 30/7/2022, the Assistant Registrar of Cooperative Societies, Hojai, gave his approval to the appointment of selection of chairman and vice chairman. Full stop. The counsel for the petitioner has also demonstrated that in the impugned order dated 28/4/2023, the observer appointed by the Assistant Registrar of Cooperative Societies, who had supervised the first board of directors meeting, was not called and examined. Full stop. Next one, under such circumstances, comma. Till the next returnable date, the court is inclined to stay the operation of the impugn order number GPSS 0.54/2020 /255 dated 28/4/2023. First of all, they said order shall not be given effect to till the next date of listing. Next, the petitioner shall produce a certified copy of this order before the Assistant Registrar of Cooperative Societies. Vijay. And a copy thereof we also provided to the Learned Standing Council for the Cooperation Department, so as to enable her to transmit the same to the Registrar of Cooperative Societies assigned. Next, list on
28/6.
28/6/2023.
Lordship, in the meantime, liberty may be provide to us to rehear the appeal.
Okay, next para. It is further provided that in the event the Registrar of Cooperative Societies Assam deems it appropriate that he would rehear the matter relating to the approval relating to appointment of the petitioner as the president of the chairman of the Nakuti Samabhay Samiti Limited. The pendency of the retribution shall not be a bar for him to do so.
My lord, I am deeply obliged.
Okay.
Lordship, recorded the order dated GPSS 54/2010, not 22/10,
Sir.
page 58, my lord, original one.
Bottom, left-hand side bottom, GPS 54/2010 to 55, page 58.
In the top, there is a error. Correct it.
It is, page 58 is the original.
No. I don't.
They have written 22.
If there are 3 pages, I don't read every page.
Yes,
Correct.
It's wrongly.
Yes. You'll have to give me some
yes,
respite from
Oh,
reading.
it's fine.
Correct.
Obliged.
Make that correction.
my lord, obliged.
27.
Yes.
Mother, yesterday Lordship had asked me, my lord, to obtain instruction as to whether petitioner will be able to furnish distributor or not. My lord. He is able, my lord. He will
Okay.
find it.
Mr. S. Hawk, Learning Council to the petitioner. And Ms. M. Burman, and government advocate appearing for the respondent
1, 3, and 4, my lord.
numbers 1, 3, and 4. Next, by filing this petition under Article 226 of the Constitution of India, the petitioner has sealed the agreement dated 6/4/2023, executed by the executive officer, Satyabari Municipal Board, Satyabari, in favor of
Respondent number 5.
the Dinamoni Haloi, DINAMONI Haloi, within bracket respondent number 5, in respect of 8 numbers of works which were advertised in short tender notice dated 9/1/2023. And to direct the said municipal board to consider the bids offered by the petitioner. Next one. The case projected by the petitioner is that he is a category class 1, Roman 1, A category contractor, and he had submitted his bid against 8 numbers of works in response to short tender notice dated 9/1/2023. Full stop. The petitioner claims that the bids were open in presence of the petitioner and other bidders, and the petitioner was successful in the technical and financial bids. The petitioner claims that he was the lowest bidder. Full stop. However, the executive officer, Sarthavali Municipal Board, awarded the tender works to the respondent of 5. Full stop. The petitioner claims that that through his friend, the petitioner had made an RTI application to
21/2/2020.
dated 21/2/2023 for certified copy of comparative statement, technical and financial of the bids opened on 2/2/2023. And it is projected that the information has not been supplied till date. Hence this repetition. Next paragraph. The matter was listed on 22/5/2023, and the court required the petitioner to take the London Council for the petitioner to take instructions as to whether the petitioner is ready and willing to deposit sum of rupees uh, 25 lakh.
My lord, it is, I have annexed this agreement, my lord, in respect of only one ward, my lord. There are some other wards also. I could not annex because their things are not available, my lord.
Okay, so 25 lakh.
Right.
Security for grant of an interim injunction, for the interim order. Full stop. Today, when the matter is listed, the London Council for the petitioner has submitted that the petitioner is ready and willing to offer a security of rupees 25 lakh. Yes, security of 25 lakh. In the event the court is inclined to stay the operation of the said agreement. Next one. The London Council for the petitioner submits that prays for leave to produce documents relating to 7 remaining works, as he could annex on the one agreement in the writ petition. So the prayer is allowed. The additional documents may be filed by way of an additional affidavit. Next paragraph. Based on the projection made by the petitioner that the petitioner was the lowest tenderer, but the works, tendered 8 numbers of works were not settled with him, and that the competitive statement of the bids was not provided to the petitioner, the fact that Jesus issue notice of motion returnable on so. Requisite extra copies of the petition be served on the government advocate appearing for respondent numbers You'll be appealing for municipal administration also,
My lord.
1, 2, 3, and 4. Petition shall take steps within 2 days for service of notice on respond number 5 by registered post to VD.
1, 3, and 4, my lord. Chairman has to, notice has to go to the chairman.
Acha, 1, 3, and 4. Okay. Then notice to 2 and 5 by registered post to VD. Notice be served on the respond number 2 by way of Dasti. By routing process to the registry of the court and upon service, affidavit of service shall be prepared prior to the next listing. Next, on service, that branch I have stated. The court is inclined to restrain the executive officer, Satyabari Municipal Board within bracket. Respondent number P. From around the,
May I point out one thing, my lord, at page 11, 18, my lord,
yes,
the term of completion of work is 2 months from the date of
it
issue
has to be
of formal
stated.
work
If
order.
somebody says that I am the lowest and you
Right.
don't assign any reason,
So
you don't
instead
provide
of
copies.
state, we be subject
This-
to outcome of writ petition, my lord.
Huh?
Maybe subject to outcome of writ.
Then what happens?
Or otherwise instruction have to be taken.
No,
on
just
that.
tell me after the work is over, what would be the outcome?
So considerable time has already elapsed.
No, I
my lord.
understand, but what would happen?
I don't know the progress of work, my lord, that is why.
And, we'll take a call. Supreme Court says that we should not interfere, but doesn't mean that
No, my
illegality
lord,
should be.
procedural aspect it can be.
You shall not permit the respondent number 5 to further proceed with the work on and from the date on which certified copy of this order is furnished to him. Next paragraph. At this stage, the learned government advocate has submitted that the time of completion was 2 months from the date of issue of formal work order. And it is submitted that as considerable time has elapsed. And the status of the work is not known. The court may reconsider the order of interim stay granted. Next paragraph. The court is aware of the various decisions of the Supreme Court of India, whereby the courts are required to be cautious while granting stay of the contract works. Full stop. However, in this case, the petitioner has predicted that he was the lowest tenderer and he was not even permitted access to the comparative statement. If there is any correctness in the allegations, then it would be the then to refrain from issuing a interim order would encourage gross illegality in the award of tender. Next, therefore, it is provided that the interim order as granted today will be subject to further orders that may pass on the next date. By which time the court expects the Satyabari Municipal Board to produce the relevant records to satisfy the court that the petitioner was not the lowest tenderer and that competitive statement was provided to him. List on when
After 3 weeks, my
this is made returnable on 3 weeks, give a date. 12/6,
my
12/6.
26th of May, my lord. 26th of
You,
May.
just a moment, next para. This, along with the certified copy of this order, comma, the petitioner shall also deposit a sum of rupees 25 lakh with the Satyavara Municipal Board. So as to make this order effective. And it is made clear that if security deposit is not made, comma, this order would have no force. The interim order possibly would have no force.
public.
Deeply.
28,
Yes,
So the petitioner reported of chief is a tenant with it. He and this was executed with the government of Assam in respect of a space in the industrial estate. Subsequently, the allotment was cancelled by it.
you see, we are not impressed with your petition because whatever has happened. But I find that there is a huge outstanding.
Yes, sir.
Correct, and the outstanding, somewhere I read some page. It would be about 20 lakhs is in 2019.
17 lakh. 2017, it was 17 lakhs.
70 lakh,
17.
17.
1,796,940.
Therefore, we are not impressed.
Final page
My
91.
contention is that, Lordship, the eviction, Lordship, but they have carried out. It is, they have served the notice by the state officer.
No, I personally feel, following Hindu tradition, you see why in a Hindu philosophy, we spend so much of money in creating god or goddess, say like Durga Puja.
Yes.
We create gods, what you call figurates. After the puja, we all
Is a god.
drown them in the water. You know why? There must be some logic why deity is created and then he or she is immersed in the water. Why?
Time, specific time. frame.
No. Unless there is a Visarjan, there can't be a Srijan.
Yes.
If the thing is lost only, then you can recreate. So your industrial shed, let it be lost. You recreate it again. If once you pay their rent,
Lordship, let them furnish the bill. I am ready. In fact, I am writing a letter.
deposit 25 lakhs within 5 days. Today is Tuesday. By Friday, you filed, provide 25 lakhs to the authorities.
Lordship, in fact, his allotment is cancelled way back in 2000.
If he pays 25 lakh, we'll consider.
So can it be lesser?
No, then you will permit you to collect these materials by paying the auction cost. And then once you pay the rent, then we'll give it to you. Because we can't encourage the government dues not to be paid.
That's it.
25 we will be able to pay.
Lordship,
Yes.
because eviction has already been done.
It's okay. You don't give it to any other.
Lordship, yes,
they make payment to you?
only his pair, here three pair, in this petition, the petitioner have three pairs, one declaration of eviction as illegal. That was already in purpose, to my understanding, because only pair.
No, you see,
is
once, no,
very
it's okay. Once you see, once they make payment to of the rent,
Lordship.
today or tomorrow you will be renting out this property to somebody else.
Yeah.
Correct. So if the petitioner is willing to take it back, why you don't have a fresh agreement and give it to him?
Lordship, to that extent, Miller,
Lordship, I will-
if
I will-
Lordship
I will-
permit me to one day, Miller.
Okay, take instruction, we'll take it up at 2 o'clock. We'll take it up at 2 o'clock.
Subject to payment of 25 lakhs.
25 lakhs within Friday, he'll deposit.
Within
that event
Friday,
you-
and in
Because,
the meantime,
in
they
the
will also
meantime-
give the statement of my arrears. The statement of my arrear balance.
Oh, you know it.
No, Lordship, it was, I
You
have
don't know the rent.
total amount they have.
No,
Given
you
for that.
you don't know the rent. Monthly rent you have to pay for the shed. Industrial shed, you don't know.
Lordship, it is from time to time, it is, there are up and downs. Let
Okay,
them furnish a
Lordship,
statement at least,
You,
because
you purchase a calculator, it will not cost you more than 300 rupees. Make that calculation. Nowadays, we have it in mobile. You don't have to purchase that also.
let's-
But still, if you don't believe your mobile, you can purchase a calculator, 300 rupees.
but the difficulty is that it is 17 lakhs, now it is 61 lakhs, they have got it. Therefore, let's say, so,
If it is 61, then you'll have to pay 61. We won't reduce the amount. Government is
I'm
if you
not-
don't pay.
not reducing, Lordship, I want to know the calculation, Lordship, how they have calculated.
We'll issue a notice within a month, they will tell you. Do that calculation because the officers will have to, you see, have to have so many meetings to make that calculation. They may have to hire a charter accountant. Because the government will not give funds for 300 rupees for
It's not that
calculator.
I am ready.
No, Mr. Datta, the difficulty is the government does not give funds for 300 rupees to get a calculator. But they will give them 10,000 rupees for having meetings and then taking a decision, audit the amount, how much it is there. For that, the government will pay funds. So we'll issue a notice, don't worry.
Lordship, I try to deposit, Lordship, will give a time frame.
We'll take it up tomorrow, by then you take instructions. Whatever dues, if it is 61 lakh, at least 60 lakh you'll have to deposit. Because you're not entertained without paying the government dues. If it is rent. You are running an industry on it. Take it up tomorrow then.
Lordship,
Get instructions.
Lordship,
Okay.
since eviction was done in the month of
It's
January,
okay. We say once they are depositing the money, then we have a soft loan for them.
if
They are running an industry.
if in the meantime not allotted to other.
Get instructions by tomorrow.
Lordship,
Because if they are making a payment, then why? is it paid?
Lordship,
It's an industry, running industry.
they have fixed the auction on tomorrow, Lordship.
Then you come by 2 o'clock.
That's-
At 2 o'clock. Be here at 2 o'clock.
Item number 3 for orders.
May I have a notice?
Yes,
In this matter, my lord, I am appearing for respondent number 3, contender
Yes.
number 3, my lord.
yes.
My lord, we have already complied with the order, my lord.
I've seen
No,
the
there
previous order. There is a
There was some
record.
delay.
There's a record and Mr.
My lord,
There
is something to
Mr. Barbara has objection because there was a delay.
That's true, my lord.
Contempt
There
has
was a
already
delay, my
been,
lord, but
today it will not be finished. Let me just take your lordship to the
No,
order.
no, there's no problem, difficulty with that. You can start
Only
the
thing-
hearing.
They will have to produce certain records, my lord. The order which has been violated, my lord, it was not only willful violation, it was total disregard, my lord. This is a case of contempt like this. Now, lordship, kindly turn to page 21 of the contempt petition. Today, I am not going to take more than 3 minutes.
No, because if I'm hearing it, we conclude the hearing today.
my lord.
No, my lord,
we have-
lordship,
We have to
kindly
file
say-
an affidavit, our affidavit. We have not been able to file, we need some time.
Lordship, just have a look at the order, my lord, which has been under violation.
I've seen that.
My lord, after service of this order, for 40 days, my lord, they have violated. The order is very specific. Last portion, it says that this court directs that till the returnable date, so and so, impute disconnection shall not be given. They still, my lord, allotted the work to the other than, my lord, private respondent. Till, my lord, 13th of April. So let them produce the, my lord, records reflecting the handling works undertaken from the date of this order, even after filing of the contempt petition for a fortnight, they didn't comply. After filing of and service of this interim order, let them produce the records up to, my lord, 12th of April, reflecting
undertaking of handling works at New Guwahati Railhead and the bill submitted with respect to those works during that period.
Mr. Barbara, what would happen if I call that in a contempt proceeding? What would happen?
Contempt has already been committed.
No,
my
it's
lord.
okay.
Then
Since-
the question of my lord, initiation of contempt proceeding will
No, it's
come.
okay.
Today, your lordship will not initiate.
No, no, not that. Since you are making a prayer, I'm just asking you, in a contempt proceeding, what would happen if I call those records?
My lord, the records should reflect, my lord, that they were clearly violating this order. It was not me. who
No, let them
was,
file an affidavit, then we'll see.
My lord, we'll file affidavit.
and
But
lordship may
how many
observe.
days, within how many days, Mr. Agarwal? Since you are facing a contempt and you are not exempted your personal appearance, by when you will be filing your affidavit?
My lord. 4 weeks, my lord, or as your lordship may please, my lord, we will file, my lord, we have. My lord, we will explain, my lord, why this, my lord, the entire problem cropped up and all that, my lord, because there were two contractors are there, my lord, simultaneously, my lord. The second contractor on whose risk and cost, the tender was called, my lord, his tender was not, my lord, his work was not
No,
terminated.
whatever be the reasons, you see, the anxiety is, the notice was issued on 1/3/2023. And you.
I appeared, my lord, on 31st, my lord.
31/3. So you have sufficient time to file your affidavit.
My lord, there was some difficulty, my lord, your lordship will kindly consider and give some time, my lord, we will file definitely.
You're fixing on 12th June, please see the calendar. Calendar should be there in the top. Mr. Agarwal, the calendar should be there in the top. The calendar should be
Yes,
there.
my lord. Yes, my lord.
My lord, I'm looking at my calendar, my lord,
Oh,
diary,
okay.
my diary, my lord.
Okay.
Whether I'll be available here. That's why only I'm. looking at them, my lord.
Can it be after 15th or not? After-
19th, let it be on 19th or 20th, my lord,
No, 20 is a Tuesday, I'm saving those
then
days.
21st, my lord.
No, my lord.
19th then,
It will be almost 1 month from today. My lord, let it be on some other day. If it is not 12, let it be on, my lord, 8th, my lord, of June,
no, early is some difficulty.
8 June.
16th then,
15th,
Huh?
15th, all right,
16th,
Thursday.
16th is
16th will
Friday,
not be there.
16th will not
I
be
will not
there.
be available.
Mr. Barbara, he will not be there.
I like definitely.
19th,
19th,
20th or
19th.
21st, my lord, any date, my lord,
19th,
any date, my lord.
19th.
And my lord, the lordship, they have denied there are two contemners, one general manager. My lord, I can state that for this period, in spite of, my lord, the very clear order by your lordship, you have not allotted works to me. It is a negative thing. So therefore, lordship may indicate that the records for this period may be produced by them with regard to conduct of handling works and, my lord.
No, in a contempt, you see, if he has committed contempt, then the law will take its own course.
Lord.
But in a contempt proceeding, I can do nothing by calling of the records.
But
Because you
affidavit
see,
should
no,
indicate.
no, Mr. Barbara, for that I have an own thought process. I may be totally wrong. It depends on how you convince me. First point is that that if you have not been allotted a work for a particular time,
In spite of court's
then
order.
in spite of court's order, then at best what you can claim is compensation,
I-
which is
That is a different
basically a civil remedy. But in a contempt,
It has been
Nothing.
committed already.
no, it's okay. But in a contempt, we can't go. We can't adjudicate on the.
No, it's all right. It's all right. Let the affidavit.
Let the
indicate.
affidavit come.
Let
If
the
it's-
affidavit
if it
indicate.
is short, then we'll see that.
Let the affidavit indicate, my lord, lordship may observe that.
No, let them.
Already one affidavit was filed by them.
Respondent one filed the affidavit. My friend will not, he is representing, Mr. Roy.
It's okay. You are for
I'm for C, my lord.
for 3. Okay.
Lordship don't have to call the records, my lord. Lordship may say that let them file affidavit indicating this period. That is the, my lord.
No, no, we'll indicate because.
No, no,
I have to
I'm not saying
explain, my lord.
anything in a contempt.
I
Let
have
them
to
file
explain,
it.
my lord, because otherwise,
Let
my
them
lord,
file it.
why I have not complied with.
Mr. A.C. Babra, Learned Senior Counsel, assisted by Miss
And they,
N.D., Learned Counsel for the petitioner.
my submission is
Mr.
recorded. That contempt has already been committed.
Roy appears, my lord, Mr. Roy, for one.
Mr. P.K. Roy, Learned Senior Counsel, assisted by me, Mr. D.K. Singh, Mr. S. Chakravarti, Counsel for the respondent number 1.
No.
submits that affidavit in opposition has been filed on behalf of respondent number 1 and 2. No, only one is filed.
Two notice was not issued.
Notice was not issued. Why?
So the court, at that point of time for treatment of that, let the notice we go to 1 and 3 only. Your lordship kindly see the order.
Okay, it's okay.
Got 14 that
1 and 3. If we mentioned that no notice was issued on respondent number 2. Next, appearing for respondent number 3. Mr. K. Agarwal, senior counsel, assisted by Mr. B.K. Singh, counsel for respondent number 3. Pays for and is granted time till 16/6 to file affidavit in opposition. We are listing it on 19th.
Okay.
Yes, sir. At this stage, the learned senior counsel for the petitioner submits that that he would insist for production of records relating to the period for which the work was not allotted to the petitioner.
in spite of this court's order.
It's okay.
Yes.
First, we take note of these submissions. Next, the affidavit in opposition by respondent number 3 shall positively be filed within 16/6/2023. Next, this is the matter on 19/6/2023.
Lordship,
Yeah.
19, I might be required to file a rejoinder to what they filed, my lord. At least they should file it by 10th, my lord. Then 19th, my lord, matter will come. I will get 1 week to file rejoinder. Today only 23rd. 19 is fixed, but their affidavit, my lord.
We'll file it on 12th.
Okay. Affidavit in opposition by 12. Reply, if any, by the petitioner within 16/6/2023, list on 19/6/2023.
Lordship.
I'm obliged.
All right.
Yes,
Lordship,
Mr. Mahanta.
sorry, Milord, in item 28, Milord, if Lordship not inconvenient, Milord, can we fix on tomorrow morning as item 1?
It is, but if it is, but if they are, you can come at the later part at 4 o'clock.
Lordship, because if since I try to contact Milord, MD is out of office, Milord. That's why tomorrow morning, because auction is still 3 PM tomorrow, Milord.
At 3 p.m.
3 PM, 3 PM.
Okay. You see, both sides are present. It appears that the file two, that the petitioner has already been evicted from his industrial shed, and that the structure, sometimes industrial shed
Lordship will find at
would be.
page 105.
No, it's okay. If I'm wrong, just tell me. Would be put into auction.
And that has already been started since 16 to 24 Milord. 16 May to tomorrow, till tomorrow. Milord.
What is that?
Auction.
Auction
by
notice
time
was
of
issued on
submission
16,
of, the quotation, Milord, started from 16
No,
5.
it's okay. It's okay. The auction will be conducted on 24/5/2023. First of the learned, Mr. M. Mahanta and counsel for the respondent number 3 submits that the process of the tendering process was initiated on 16/5/2023. And the submissions of tender would be open till
Tomorrow
Tomorrow at 3 PM.
no. Submission of tender till when?
till 3 PM tomorrow, Milord, 24 Milord.
Till
3 PM, Milord.
till 3 p.m. on 23/5/2023, and thereafter the auction will take place on
Also same day,
On-
Milord.
on-
Opening
on
of
the-
the
at 3 p.m.
sorry, 24, the
24.
auction after that. Full stop. Next para. The learned counsel for the petitioner has submitted that the that as per the uh, demand raised, comma, as on, where is that page?
Lordship will find at page 91, my lord.
Page 91.
This is the cancellation. As on February, 1st February 2020, my lord.
Is that as on 9/6/2017, the lease rent due from the petitioner was rupees 17,96,942. It is also submitted that as on date,
But it is on the
The-
date of cancellation of the allotment, let's say it was the amount. And thereafter, after cancellation, perhaps they cannot.
no,
claim.
is the date wrong? 9/6/2017 is wrong.
Lordship, cancellation was on.
No, whatever I am not writing a detailed order now.
Let's say.
I'm just giving an indication.
Lordship may take note of page 90, my lord. That is the so
91.
90. That was the so number in 19, and cancellation was in 91. my lord.
Okay.
Same amount. There is-
And thereafter, the lease was cancelled on 1/2/2020. It is submitted that as per rough estimates, the lease rental would cross to be 61 lakh by now. Next paragraph. In view of the huge rent due from the petitioner, comma, the petitioner is put to notice as to whether they are ready and willing to deposit at least rupees 60 lakh to the respondent number 3 within the working hours of 26/5/2023. The learned counsel for the petitioner. It's time for instructions and we'll revert back tomorrow. We'll revert back tomorrow. Next para, the learned counsel for respondent number 3 has submitted that he has tried to contact the managing director of respondent number 3, but he was out of office and could not be contacted. So he submits that although the petitioner has been evicted from the industrial shed, he would still have the instructions and will revert back tomorrow. Next, accordingly, list this matter in the motion column on 24/5/2023. Next, the petitioner is at liberty to make a mention for upgradation of the matter.
Let's send the amount. Let's say that.
Hmm?
The amount. I have to deposit.
No, I've said 60 lakh within 26/5.
Can it be because 17 just before cancellation of allotment, it was 17 lakhs. Let's say.
No,
Initially,
but this,
After
you were evicted
cancellation.
when? You were evicted when?
I was evicted in 20 after that notice. Let's say.
Immediately then.
Immediately.
But then we can't revert back. If the eviction is in 2019, we are in 23 now.
20, yes.
Now we can't put back you in the, I was under the impression that you are still in occupation. But if you have been evicted, then this would not be required. Because I can't put you back. The clock can't be put back.
Anyway, let's say I talk with my client tomorrow.
In submission of Mr. Monthly said this, that he was evicted on 1/2/2019.
Lost. No, my lord. His cancellation was in February 2020, my lord.
He was
And-
evicted
and,
when?
Evicted on, my lord, 25/1/2023.
25/1/23.
25/1/23.
2023. Because
Allotment
during
was
this period, my
cancelled
lord,
on 1/2/2000.
date of cancellation till eviction said was under his possession.
Okay. Okay. Okay, get that information, we'll see tomorrow.
14 to 18 stay matters.
On this, I think few days back, I read one of the orders of a coordinated bench of this court interpreting rule 18(2) of the and 18(3) of the Assam Land and Revenue Regulation. You are aware of it? You just wait, the petitioners are not there. After some time. Let's see. They will come after admission will come here. Hmm? Mhm. Item 20. Yes, item 20.
20,
14 to 18.
Yes,
My sin is in another court. My kindly that matter be taken up.
after some time. Okay.
20,
Yes, Mr. Sigdar, your matter.
20 minutes. Yes, my lord. We have to file and reply affidavit, but because of some difficulty of the person taking stay, but we will file, my lord, within the next 3 days, my lord. I may be given some short time.
Mr. Barwa, you are appearing as CGC in the matter? Mr. Barwa, you are appearing in this matter as CGC?
RDB is there. RDB is there. 20. RDB is there. She has,
RDB is there.
she has filed affidavit.
Also is a duly represented on the prayer made by Mr. A.R. Siddhar and counsel for the petitioner. 1 week's time is granted to file affidavit in reply in the matter. So it is made clear that if affidavit in reply is not filed by the petitioner, the matter would be heard on the basis of materials available on record. You will fix date. after the
26,
Well, interim shall continue.
interim order passed today, can extend it till next date of
Please,
this.
lovely.
21,
My lord,
Yes,
my lord, the LOI is issued in favor of this respondent number 3. I am from respondent number 3 for dealership. My lord, they brought up allegations that second.
there's an interim order, whatever happens, we'll see. There's an interim order operating. If it is, even if it is allotted to you,
PCL has not filed any affidavit. And what I'd like to propose, my lord, HPCL, they can hear all parties and take a decision in the matter. Because what they have done is page 28, your lordship, can you see? I am serial number 2. I've
You are
been selected-
appearing for HPCL?
Yes, your lordship.
Yes, what is the reason?
What had happened, lordship, we have showcased after receiving a complaint from them, lordship, we have showcased the LOI holder, lordship. He denied that, lordship. Now, lordship, fact, Siemens, lordship, it is a disputed question of fact, lordship, whether this court can go into.
What
No,
I,
let us hear you, because if it is a disputed question, how would you go about it?
Lordship, that's why, lordship, we are also still holding that what we will do, lordship.
No, because
have-
one of us will have to take a decision. If the HPCL doesn't take a decision, then we'll have to take it.
Lordship,
What do you propose? Do you accept the contention of Mr. Das?
lordship, that because our LOI holder has denied the fact, lordship, that he had signed this, lordship.
I disputed that to that effect, some evidence also I produced. So I disputed that I have.
so let
signed
them
this.
hear all sides and take a decision, my lord.
So my rights has been stalled.
Well, only page 28 may can be simple.
Page?
28. This is the, because he is at serial number 1, respondent number 3, I am at serial number 2. So if he doesn't get it, I get it, madam. Page is clause 8.
Where is your complaint?
Now, my complaint is at page 38. And I'll just point out this, your lordship will be clear, madam. Clause 8. You shall not induct any partner in case of individuals, nor make any changes in the constitution of the partners as they existed at the time of application without the approval of the company, except your spouse as per terms and conditions of the Hindustan Petroleum Corporation. Now, what they have done, my lord, page 31, my lord. This is the agreement signed with respondent number 3, respondent number, no, respondent number, my lord, Abdul Khalik. 4, my lord. This is the agreement signed. So this is in violation of clause 8. So we filed a representation. Representation is at page 42, my lord.
Okay,
Starts on
then,
page 38.
then what we'll do is
So we filed a complaint, my lord, as regard violation of clause 8 against, my lord, respondent number 3. And now their reply is that we have asked respondent number 3, respondent number 3 denies. Therefore, we have nothing to do in the matter. Yeah, absurd, my lord, answer, my lord.
who's appearing the state? Anybody is there for the state?
State is not necessary.
No, in view of the dispute,
Lordship.
we direct the deputy commissioner, Ms. Burman,
My lord.
we direct the deputy commissioner to call for the notary diary
Yes, but
of
the
page
here-
35.
Here, lordship, what had happened, the notary has died,
diary is
that
there.
notary died.
He died.
Right.
Okay.
But already verification has been done on the personal endeavors of the respondent 3 notary. And the identifier says that I have not identified these persons. It may be other persons and this signature specimens are not tally with the signature of notary diary matter. So that may be examined by a government mind. Come to the conclusion. But identifier advocate has already clarified. That is why we have annexed this his clarification. That person I have.
Where is that?
And in affidavit, my lord, regional affidavit, my lord. Page,
Give the running page number.
page number is my lord, page 95 onwards, my lord. 95 is this queries to the identifier. From Mohiduddin Ahmed, DLLB, advocate of Dhubri Bar. Clarification regarding signature of the documents. These documents identify that person, that notary, not identified, not notary. 21 days. And specimen signature is given, my lord. The respondent. And the reply came, my lord, after. Reply is page 97.
Vernacular, but in this letter itself, they did sign this one. Paragraph 5 मध्ये signature can as both signature does not present.
But then, Mr. Das, we have to relegate you to the civil code because this is something which can't identify. This is something,
Your lordship, can you see this agreement, what they are saying?
but read code, this can't be determined.
I'm not saying that, Malay, your lordship will relegate the matter to the authorities itself. They will hear all parties and decide the matter. Otherwise, what they are saying, Malay, your page 95, your lordship will kindly say.
No, because you see, there is another issue.
Yes.
This, even if we send that matter for a decision to the HPCL,
Yes.
SPCL people are not experts. They will only record.
Deputy commissioner, they have all this registered, this notary is there, notary is
If the
registered.
notary is right, the register would not be there.
I think registered will be there, my lord. Notary registered. So then notary.
No, why deputy commissioner? It is otherwise determinable by in a civil court or if you file a criminal case, then only that can be determined. But why would the High Court give a direction?
Because the matter is pending for a long time, everybody has filed affidavit in opposition. Even the witness and the respondent number 4 and respondent number, my lord, 5, 6, 7, they have filed their affidavit. And they have said that they have signed the agreement. Where is the question of disputes?
Because you see, this page 97, the law who identifies says that it doesn't tally.
No,
If it-
page 95, your lordship can you see? 95, his signature is there in SMS. 95, my lord, his signature is in SMS. They say, my lord, my signature is different. I sign only in English. But his signature his signature is, my lord, in SMS. Page 95, he has addressed a letter
No,
to
this
the,
is okay, but you see, 97,
yes.
the advocate says that you find that both signatures do not tally with each other in the register, doesn't match with you. The
But this
difficulty is there.
signature here, lordship will kindly see the affidavit filed by respondent number 3, the respondent number 4, 5, 6, and 7. Respondent number 4 is, my lord, your lordship will kindly see page.
Give the serial number, page serial number, running page,
It's 56. I think it is 56.
56.
Yes.
Yes,
4 to 7,
56 is
we have filed it.
respondent number 4.
4 and 7, 4 to 7.
That we dig a paragraph 4, my lord, with regard to statement made in paragraph 3, 4, 5 to the writ petition. The opponent does not want to comment on the same as the same are a matter of record pertaining to the advertisement so and so, so and so. Then, my lord, with regard to 6, the deponent respondent says that the deponent has executed an agreement with respondent number 3 on so and so, whereby the deponent was allowed by the respondent number 3 to construct the said depot of petrol pump on the scheduled land, and also to do all the government work by the deponent for establishment of the depot in the reference. In the said agreement, it was also agreed that the respondent number 3 will provide the share of business of the petrol pump by executing a separate deed. The deponent respectively states that the deponent and the
you
respondent
are
number 3
reading where, which paragraph?
paragraph page 58, paragraph 5. This is and regarded, this is with the person respondent number 4 with whom the agreement was signed. The
Respondent
deponent,
number 4 is Abdul Khalik Bepari.
Khalik Bepari.
Yes, yes, now please read.
Yes,
Please read paragraph 5 again.
yes. That with regard to the statement made in paragraph 6 to the writ petition, the deponent respectively states that the deponent has executed an agreement with respondent number 3 on on 16/5/22, whereby the deponent was allowed by the respondent number 3 to construct the said depot of petrol pump on the scheduled land and also to do all the government work by the deponent for establishment of the depot in reference. In the said agreement, it was also agreed that the respondent number 3 will provide the share of business of the petrol pump by executing a separate deed. The deponent respectfully states that the deponent and respondent number 3 put their signatures in presence of the witnesses who have been implemented as respondent number 5, 6, and 7 in the present date petition. And the said agreement was notarized on so and so by the respondent number. Now, respondent number 5, 6, and 7, they have also filed affidavit. They say that yes, we are the witness. That your lordship will find at page 69. We could not get the notary because he died. Paragraph 4, page 69 starts from page 69, page 70, your lordship will see.
Who are these 5, 6, and 7?
Yes, 5, 6, and they are witnesses to the agreement.
Yes.
Paragraph page 70,
Where is that agreement? Please come again.
agreement is at page 31. madam. This is the type copy. And copy of the original is at page 34.
Yes.
Duly notarized.
Yes.
What is surprising is, my lord, page 44. Page 44, we filed a complaint saying that he is violating your clause 8. And they say we have asked that person and person says he has denied. Page 44. To Sanjit Das, your prayer for cancellation of LOI so and so. My lord, we take a paragraph 6, right? With regard to point number 4 of your complaint, we had issued the letter to LOI holder, that is respondent number 3, seeking explanations about the agreement signed with Abdul Khalik Bepari. We have received his reply in which he has denied having signed any agreement. My lord, I filed complaint against respondent number 3 and they have asked respondent number 3 whether you have signed any agreement. And respondent number 3 says, my lord, I have not signed. So therefore, the reply has been provided to me. This is the violation of their own clause. My only interest is that, my lord, I am serial number 2. So let them hear, my lord, whomever they like and decide the matter. But this cannot be the answer that I have asked respondent number 3. He denies it. Therefore, we cannot do anything. My lord.
We have to show cause lordship. We have to show cause him, otherwise lordship.
My only contention is that the reply is without application of mine. So they are the authority. They should see whatever reply they give. They should be logical. It cannot be without application of mine and arbitrary, which is on the face of it not correct.
Yes,
My
Mr.
lord,
Verma.
thing is that is only documents which they relied. So I have denied it. So burden is upon them to give a positive evidence that yes, I have signed. To my extent, I have given this clarification. Now to hijack my rights or taking my rights, they should have the positive evidence, my lord, rebuttable evidence, or so they have not done anything, only seeing that a notary was not there. That is why unfortunate, but identified has said that I have not identified. And verification, this register is also there, my lord, notary register also there. So in that situation, my lord, it is a disputed facts, and that is their burden to prove positive evidence, my lord. I have denied, rebutted it. It is their duty, my lord. Whether at this stage this report can take away my rights, because I am the first one selected. LOI is issued in my favor, but it's stalled for 1 year, my lord.
Yes, Mr. Saiwala.
I am the party to the agreement. And I have filed the affidavit and said that this has been done. And 5, 6, 7, no 6, the 3 witnesses are there. They also supported this. But what is there? That fact it will be considered by the That fact is not considered, my lord. Just the, my lord, asking the responsibility, my lord, they have replied to that letter. Correct, my lord, position. As per their own, my lord, the norms, my lord, they have to decide it properly. They should have called the responsible for, my lord. Especially allegation here.
No, one of the allegation of respondent three is that the petitioner with collision with all others make an conspiracy. So they have to prove it in positive manner.
That is,
Otherwise, they are the outsiders, some outsiders, they have not taken it. And somebody is that, yes,
it's not the claim purpose should have, my lord, the consideration. After that only they can take it.
so positive proof or declaration may be brought that, yes, this document is signed by this respondent number three. So that is why they added that clause. Otherwise, contents of the agreement is nothing to do until it is manufactured documents. It is the contention of the respondent three, that some manufactured documents is produced with collision with 2, 3, 4, who is brought as a witness, and petitioner right to take these rights by this.
Signature itself will prove it, my lord, in that part of the contract. Because the signatures are there with the contract.
Okay. I'll consider in pass orders. I'm fixing it on Monday for delivery of orders.
Well, only one aspect of the matter I would like to point out. Page 34, this is the original agreement, page 34. On the face of it, my lord, and the answer given by the authorities on the face of it without application number.
Just
Page
a moment.
34, that Chontu Sutro's signature, your lordship will see. And page 34, this is the agreement original. And page 95. This is the letter which has been written by the Jontu Sutradhar to the advocate, identifying advocate. Your lordship will see the signature. On the face of it, I think, my lord, it speaks volume. I leave it to your lordship. But the authority cannot answer in this manner, my lord, that I have asked respondent number 3 and respondent number 3 denies it, so we will not look into it.
But on a visual, I'm not an authority on signature, but on visual inspection of page 35 and 95,
Yes.
they are not the same signatures.
My lord, page 35 and 95, I find it is same.
No, you see, there's a reason for that, Mr. Das. I'll tell you why.
My lord, your lordship.
No, I'll tell you why. There's a reason for that. And I find that there's a basis in what I'm saying. You see,
Yes,
in I have talked with many young boys and girls from various parts of the state.
my lord.
Correct. From Dhubri to what you can say Tinsukia and then Silchar.
Well,
There are a class of people, even if it's a girl, you ask her what is her name. Say, for example, any name you think of. Let us say Mosmi Chatterjee. So you ask the girl what her name is, she will reply, Sri Mosmi Chatterjee. That females also use Sri in villages, correct? And even the boys, even my clerk which is with me, even in the court, my clerk, you ask them the name, he will add Sri to his name, and while signing, he will always write, even the boy and a girl will write Sri. This is something they will never change. Correct. I have tried to tell the females also that Sri is, it may be Srimati, but still again they will say their name as Sri. In this agreement, Sri is written.
Yes.
And Sri is omitted here. So man by
In the
habit.
letter- In the letter, it is because she has written normally. when
No,
I
it's
write-
okay. I'm just telling you that there's a reason for why I'm saying that.
But Mosumi Chatterjee, but it is always better to go for Priyanka Chopra. She is alive in the.
No, because after 2016, I've rarely been to movies. I have never.
Mosumi Chatterjee nowadays, she is not in the screen. Pavela would like to speak of Mosumi Chatterjee.
When I am about to be strangulated with all my family members, then I think after 16, 2 or 3 movies I have gone, not more than that. Only out of fear of strangulation.
I'll leave it to you. My.
Because there I always envy you. In this aspect, I always envy you. Because Mr. Das travels even to other cities to watch theatre. Okay, heard Mr. B.D. Das, Senior Counsel, assisted by Ms. B.B. Hussain, Counsel for the petitioner. Also heard Mr. S.S. Roy, learned CGC appearing for.
Lordship 1 and 2, HPCL.
Acha, the learned Counsel for respondent was 1 and 2, and Mr. M.J. Barua, Counsel for respondent number 3, and Mr. G.N. Savara, learned Senior Counsel, assisted by Mr. K. Kalita, Counsel for respondent number 4 to 7. The arguments are concluded. List on give Monday for delivery of orders.
For hearing 4 to 13.
Yes. Yes, Mr. Pawar.
Yes, sir, Lordship, the learned is he supposed to appear, but since he is out of station, you will say I am appearing.
Yes.
Lordship, for the factual part, your Lordship, for
Just a moment. Let me recapitulate what I have remembered
Yes,
so that. Earlier, when you had made submissions,
yes, sir.
you were relying on the Assam Panchayat Raj Act, section 29,
Yes, your Lordship.
1986. And
1986.
you were saying that the authority to appoint the secretary of Gram Panchayat is the director. And
Yes.
that none of the petitioners were appointed appointed by the director.
Yes, sir.
So you are saying that the appointment is illegal.
Yes, sir.
That is your argument, number one. Second, you are saying that these 1 to 72 posts were not created, and therefore persons were appointed without sanctioned posts.
Yes, sir.
You are also relying on Ashwini Kumar,
Yes, sir.
state of Bihar.
Yes, sir.
But you see, when the government has accepted and appointed them, the question is that you are accepting their regularization, but you are giving the effect to a later date so that this pension can be avoided. So once you accept that stand,
Lordship, the
you accept the regularization from an anterior date. You could not have imposed that condition for pension to be at a later date. Because you see, there were 4 queries. Number one, no one has declared that the employees were illegally appointed. Correct. The second is that despite section 2D of the Provincial Administration Act of 1999, section 3 says refers to all employees. Therefore, there is a validation by the act. That is the second query. Third is that all the regularizations were given effective from 4 to 2006, and that the petitioners had joined on or before 10/6/2003. Therefore, if that position is accepted, how can you put these petitioners to the pension scheme for 1 to 2005? That are the 3 queries based on your submissions.
yes, yes.
You're also relied on Renew and others 2014 SCC 50. I'll just take a short break and come, then can.
Yes. The so far as the appointment by incompetent authority, Your Lordship, against non-sanctioned post, Your Lordship. Your Lordship, I would like to rely on decision of Indi Uma Devi, Your Lordship.
Yes.
Lordship, there are cases that since 1993,
Since you gave effect from that date, then why pension could be postponed? That is the only ground.
yes. There are cases that they were engaged in the 1993 and 94 against value authority, and they are continuing without any break, Your Lordship. So their service should be considered from the date of their initial engagement, Your Lordship.
No, not only that.
Right.
You gave effect to that what you call regularization with effect from a back date. Therefore, if that takes effect,
Your Lordship, did in 2003, Your Lordship.
yes, that is what I understand. That's why I repeated what I've understood till now.
2003,
So once you give effect to a date anterior to this 2005,
In the 2008, in the 2003, Your Lordship, the regularization order was issued. The page 28 of the writ petition, Annexure 1. There was another. And in that regularization order, Your Lordship, the regularization of service will be effective from the date of issue of office order by Chief Executive Officer of the respective Jilla Parishad in this regard. So
where is that? Which page?
page 28, Annexure 1, Your Lordship.
28, yes.
Yes, 28. Annexure 1. This is the letter, Your Lordship, issued by the Joint Secretary. It was issued on 30 30th May 2003 year also. Here, your lordship, regularization date of effect, regularization was given from the date the chief executive officer, the date when the chief executive officer issued the regularization order with the respective GP secretaries. Your lordship. May I read your lordship?
Yes.
I am directed to convey the approval of the government of Assam to regularize the services of 1,707 numbers of engaged Gaon Panchayat secretaries as per list enclosed in the scale of pay such and such, plus other allowances as admissible from time to time. The regularization of services is subject to discharge without notice and without assigning any reason thereof. The employees so regularized will be treated as employees of Panchayat Raj institutions, and they will get their salaries from their respective TRIs. The government of Assam will reimburse the entire expenditure of 1,707 numbers of GP secretaries out of the budget provision under the head of accounts such and such. Next, the regularization of services will be effective from the date of issue of office order by the chief executive officer of the respective Jila Parishad in this regard. So, your lordship, this regulation was done by this, for this later, your lordship, with a prospective date.
Page 30 will show you that it is prospective. You are right.
Yes.
Page 30 says 2/6/2003.
Your lordship, the in pursuance of the district declaration of Panchayat in the date of plus other elements admissible from time to time issued by the said order is may effect from 2/6/2003 in the respective GP shown against each list of GP secretaries in appendix. This is the Karimganj Jila Parishad chief executive officer of Karimganj Jila Parishad issued this order. One of the orders, such
No,
orders.
one of such orders, and page 34, come to page 34. This clause 3 of section 1, it says it shall deem to have come into a force on October 1991. Therefore, this is the legislative prescription.
Your lordship, the is that your lordship, the section 2, clause D, your lordship, may kindly be seen.
Clause 2D,
2D.
employees means a
Employees,
person
the meaning of the employees, your lordship.
regularly sanctioned post.
So, your lordship, at the time of regularization, no post were created. It is subsequently created in the year 2006. So, your lordship, it says the employees. Employees means a person in the employment of Panchayat against a regular sanctioned post. And in this section 3, the next page, your lordship. page
Mr.
35.
Kumar, there will be some difficulty in understanding. You see, number one, let us say school teachers.
Yes.
We forget this for the time being. In school teachers, when you are provincializing the service of venture schools,
Yeah.
correct? Now, is it the stand of the government that the posts should be a sanctioned post?
Lordship,
In a venture school, there will not be a sanctioned post,
Yeah.
correct?
your lordship,
So if these appointments were made, this act is for regularization. The fact that there should be a sanctioned post is a misnomer. If there is a sanctioned post, they are already government servants. You don't need a provincialization act for that.
your lordship, so far as the school teachers are concerned, at the time of provincialization, we create schools.
Correct, that's what I'm asking, I'm drawing a parallel. You
Yes,
see, therefore, when you are provincializing service,
yes,
that means they are not government servants. On the day you are provincializing them.
yes.
So if they are not government servants, can they be appointed? Can you think that they would be appointed in a sanction post?
Your lordship, the in the Panchayati Raj institution, they will have to work against the post which are in the Panchayati Raj institution. The staffing pattern.
Okay. Secretary is a post which was not there in the Panchayati Act.
That is there, your lordship.
Then,
That is there,
but
it was not created.
no, definitely it was, you see, it was not a government institution then. Panchayati Raj institution was under the Act and they were not government servants then.
Your lordship, yes, they are, this is autonomous body, your lordship.
They were employees of the autonomous body.
Yes.
So therefore, in an autonomous body, if the Act of 94 says that there should be a secretary, and the secretary they are in that post,
Yes. Yes.
you see the difficulty.
Your
The
lordship,
Provincialization Act
yes.
presupposes that they are not government servants. Otherwise, there will be no provincialization.
Yes.
So therefore, in the Act is nothing but a printer's devil. They have copied from somewhere and this has remained. But in fact, if we read this provision of 2D,
If your lordship petitioners intends to take the benefit of the act, then they will have to abide by all the provisions, your lordship. And moreover, your lordship, in the Provincialization Act, there is no such provision for regularization against non-sanctioned posts.
yes.
Lordship, your lordship may kindly see page 40, your lordship, Annexa 5. The governor of Assam, this is the governor of Assam is pleased to regularize and provincialize the services of 1,707 numbers of Gaon Panchayat Secretary, which prospective effect. Out of 1,707 posts, the services of 435 numbers of Gaon Panchayat secretaries created by number such and such dated 17/2/93. Your lordship, in the 93, 435 posts were vacant, your lordship. Are regularized against sanctioned vacant post, and the services of remaining 1,272 numbers of Gaon Panchayat secretary are regularized against the post created for the first time on 4th of February 2006. So there is the two.
Qualifying service starts from 2006.
So your lordship, at best, they are, so far as provincialization is concerned, their qualifying service will be counted from 2006. 1272. Even in the earlier in the proceeding, your lordship, the coordinate bench has observed that way, your lordship. From there,
Where is that order?
Your lordship, at 41, your lordship, 41. Page number 41, it starts from page number 41. Relevant paragraph at page number 44, your lordship, paragraph number 9. It is also not in dispute that in order to enable the government to make payment of salary for the said period to all Gaon Panchayat secretaries, provisions for a sum of rupees 34 crore will be required to be made by the State Finance Commission. The government undertakes to make payment of the said salary as and when the Third Finance Commission so make provisions. As far as the regularization of the said period of service of the petitioners is concerned, it is clear that so long as the order dated 4/2/2006 stands, the petitioners would be entitled to the computation of their period of service rendered as Gaon Panchayat secretaries with effect from 4/2/2006 and not before. When the substantive post were first created. So, your lordship, since the substantive post created on 4/2/2006, your lordship, established. And in a pensionable establishment, also. Here in this paragraph, the two parts is there. Two parts is there, are there. Also in the first part, the state has given the undertaking that on their own volition that the period of the regularization, the area salary will be paid, provided the State Finance Commission grants it. So far as the other part is concerned, it is specifically said by the learned coordinate bench, your lordship, that 4/2/2006 will be cut off date, not before.
But then how do you reconcile your submission with page 54?
Is in terms of the order of Ansari. This is the fallout of the learned coordinate bench judgment, your lordship.
No, but here it is for the period sanctioned post for the period 35/2003. This date has come in.
Observation, no consider. Consider. Ex-post notification of the post is accorded to the section. Location your lordship, this is for a limited purpose, your lordship. As we have given the undertaking before the learned coordinate bench, your lordship. So, your lordship, we have given them ex post facto approval, your lordship. But in ground reality, no post was created till 4/2/2006, your lordship. And your lordship, so far as the qualifying service is concerned for pension purpose, your lordship, it starts from the day they have taken charge of a regularly sanctioned post, substantive post, that they have taken after 4/2/2006, as they have taken. Because after 4/2/2006, your lordship, the redeployment order was issued to all the GP secretaries. They have accepted it. They join in the redeployed post, your lordship. And then, your lordship, they have given the undertaking that their service will be governed by a new pension scheme, your lordship. Now, in a belated stage, your lordship, they have contributed regularly to the NPS. So now, in a belated stage, that is, it is not permissible for them to agitate it because they have accepted it. Benefits of the yes.
Yes.
Your lordship, for your lordship's convenience, your lordship, your lordship, in the writ petition number 5123/2018, your lordship, Gubin Handy case, your lordship, here they have
Yes.
your lordship may kindly Niranjan Malakar's case, your lordship. 4925. Here, your lordship, in the
No, 5123 you are saying.
oh, yeah, lordship, they have in that matter 5123, they have annexed the redeployment order, your lordship. Redeployment order, your lordship will find it at page number 46.
Page 46.
Yes, your lordship. May I read it?
What is this redeployment order?
Yes, your lordship. Redeployment order. In pursuance of government notification dated 4/2/2006, the following newly provincialized Gaon Panchayat secretaries serving in the Gaon Panchayat under non-6 schedule areas are hereby redeployed in the respective Gaon Panchayat as shown below against their names in the sanction posting. Sanction by government letter dated 17/2/93 and 4/2/2006. However, this redeployment is subject to the outcome of the restriction. In the page number 48, your lordship, the concerning Gaon Panchayat secretaries will have to submit their joining report and to sworn and undertaking appended with the reference to this redeployment orders. And accordingly, they have submitted the undertaking, your lordship. In the way back 2006, your lordship.
Yes.
In another matter, your lordship, Niranjan Malakar, writ petition number 4925/2018, your lordship. Niranjan Malakar, WPC 4925/2018.
Yes.
Page 39, they have annexed the undertaking in this petition. May I read your lordship? Undertaking, keeping conformity with the undertaking to be furnished by government servant joining the service of the state government on or after 1st February 2005, as has been issued by the government of Assam Finance Budget Department by Office Memorandum Letter Number such and such dated 25/1/2005, which speaks as, I understand and accept that government servant join the service of state government or after 1st February 2005 shall not be governed by the existing Assam Services Pension Rules 1969 and orders issued there under from time to time, and that their pension and other benefits will be governed by a set of new pension rules which are formulated in the line of the contributory pension schemes of Government of India and going to be notified in due course. I shall be bound to follow the direction in regards to the pension and other retirement benefits or otherwise as may be decided by the government. This is the undertaking they have given. All the lead petitioners. Your lordship, so far as their provincialization order is concerned, that is conditional. And they have accepted it.
Just a moment. Yes.
Your lordship, the provincialization order, it was conditional. And they have accepted it. Now they cannot say that the favorable part will be accepted by them and the unfavorable part cannot be accepted in such a belated stage, your lordship. In this matter, your lordship, I would like to refer to a recent judgment of this Honorable Supreme Court, your lordship, MP Palaniswamy and others. In this case, your lordship, in paragraph 19, page number 14, your lordship, may I read, your lordship? Yes. Page number 14, your lordship.
Yes.
Page number 14, paragraph 19, and the last line, your lordship. The last line, your lordship. it cannot, it starts as it cannot. It cannot be forgotten
Yes,
it cannot be forgotten that this regularization was all along accepted by the present appellants. Once they choose to accept the regularization, which was conditional, then it would have to be borne in mind that they have accepted the conditions also. It cannot be countenanced that only the favorable part of the GOMS was accepted by them and the unfavorable part was rejected. If they had to do it, they had to challenge that GOMS immediately. They did not do it. Instead, they waited almost for 6 years when for the first time they came out with an original application. So and so. Your Lordship, they have accepted the provincialization. And in the earlier round of litigation, learned coordinate bench did not interfere, Your Lordship. Rather, it says that 4/2/2006, from the date of 4/2/2006, the qualifying service will be started.
yes.
Your Lordship, I'd like to refer to this Rule 31 of the Assam Services Pension Codes 1969. The conditions of qualifying services. Page 24.
Pension was by.
Rule 31 H. Page 24.
Yes,
The Rule 31 speaks about the conditions for qualifying service. The service of an officer does not qualify for pension unless it conforms to the following 3 conditions. Firstly, the service must be under government. Secondly, the employment must be substantive and permanent. Their substantive appointment came after 4/2/2006, while provincialization notification was issued, Your Lordship. And thirdly, the service must be paid by the government. Your Lordship. So far as the Your Lordship, the first and second conditions are concerned, they have fulfilled since it is fulfilled since 4/2/2006 at best, Your Lordship, not before, Your Lordship. Second condition, the employment must be substantive and permanent, Your Lordship.
was 4/2006.
Yes, Your Lordship.
Yes,
Your Lordship, during the petitioner's argument, they have raised the They have raised the issue, Your Lordship. They have relied on the report of the second Assam State Finance Commission. Your Lordship, in this event, Your Lordship, our reply. The first item, Your Lordship, was WPC number 4506/2018, Your Lordship. In the learning coordinate bench judgment, Your Lordship, page number 43, Your Lordship, paragraph 6 and 7 may kindly be seen, Your Lordship. In that round of litigation also, they have relied on that second State Finance Commission report, Your Lordship. Paragraph 6, page 43. Lordship, fancy.
Yes.
Paragraph 6, Your Lordship. From the report of the second Finance State Commission published in August 2003, what however transpires is that as on the date of submission of the report, what however transpires is that as on the date of submission of the report, there were altogether 2,390 sanctioned posts of Gaon Panchayat secretaries, including 1,707 Gaon Panchayat secretaries, whose services had been regularized, but as many as 97 posts of Gaon Panchayat secretaries had not yet been sanctioned to accommodate all the Gaon Panchayat secretaries whose services had been regularized by virtue of the order dated such and such aforementioned. In the next paragraph, the paragraph 7, you will see. Next page. From the affidavit submitted by the state respondents, what transpires is that though the services of as many as 1,707 numbers of Gaon Panchayat secretaries were provincialized and regularized, adequate number of sanctioned posts neither existed nor had been created till 35/2003. The requisite number of posts appeared to have been sanctioned only by notification dated 4/2/2006. If the submission of the state respondents are accepted, the petitioners would not be entitled to receive salary for the period of that case was filed for area salary, Your Lordship. So, Your Lordship, the ground reality is that although it is reflected in the second Finance Commission report that such number of posts are existed, but however in the ground reality there was no adequate post rate there, you know, till 2006, Your Lordship, because the post rate created on 4/2/2006 only. In their argument, they have raised another point, Your Lordship, that they were working as regular employees of Panchayat Raj institutions, and subsequently their services have been provincialized by the government by its notification dated 4/2/2006. As such, their past services should be considered in the case of fixing their pensionary benefits. Your Lordship, I'd like to refer to the particular provision 140, section 140 of Assam Panchayat Act 1994. Page number 142. So, don't get away. Section 140 also. To be a PRI's regular employee, one should be
Which provision?
140 also.
140?
140.
140. Staff selection board.
Staff selection board, yes. Yes, sir. District selection board committee also.
Just a moment. One 148 of Assam Panchayat Act 94.
Yes, yes.
140 says staff selection board.
Yes, yes. Staff selection board.
Yes.
Yes. May I read your lordship? Your lordship, the thing is that your lordship, to be a PRI's regular employee, one should be employed following the procedure mandated by this particular provision, your lordship.
Pardon me, please repeat again.
To be a PRI's regular employee, your lordship, as they are claiming that they are the regular employee of the PRIs. But your lordship, to be a PRI's regular employee, the petitioner should be employed following the procedure mandated under section 140 of the Assam Panchayat Act 1994. That was not done. Not done also. May I read your the provision?
Yes.
140, section 140, subsection 1. For Jila Parishad, Anchalik Panchayat and Gaon Panchayat, grade 3 and grade 4 staff shall be appointed by the Chief Executive Officer of Jila Parishad on the recommendation of the District Selection Committee of Panchayat and Rural Development Department, constituted by the government in the Panchayat and Rural Development Department. Here, Lordship, the GP Secretary is the grade 3 employee. No such selection was made and no such appointment was given to them. And at the initial stage, your lordship, they were engaged by incompetent authority in violation of the provision under the old Act, your lordship, 1986 Act, your lordship. And subsequently, the 140 is not followed. At best. So, your lordship, my humble submission is that, your lordship. Here, services, government services will be counted from the date of 4/2/2006, your lordship. The post date of after the creation of post, your lordship, not before that, your lordship. The qualifying service will be counted from 4/2/2006, your lordship. And it was also observed by the earlier litigation, your lordship, in the learned coordinate bench, your lordship. And one point that I would like to place before your lordship, another is the your lordship it will have to be seen, your lordship, whether they are barred by doctrine of res judicata or not, your lordship. That will be seen, your lordship. That's all, lordship. I am summing up, your lordship.
You got nothing more to add?
Nothing more to add, my lord. Only one thing, my lord, that some districts, some people had
sign this. That will not make any difference. My lord, Bojana Ganguly's judgment is there. Equal, unequal bargaining power. That by itself will not be the determining factor. Another factor which my lord will also keep in mind, only two things I've just said, my lord, that emphasis on rule 31 of the pension, some pension rules, my lord, that will be applicable in our case for considering the period prior to 2003.
Yes,
That will, my lord, be for the period prior to 2003 from 1991-92 when we had joined. That period, I had made a submission earlier also, my lord. That period, my lord, need not go into. That is for the government to consider. How that period, my lord, they will begin, and therein 31 can be got. But the period from 2003, my lord, first PRI, if we are PRI, we are covered by the Provincialization Act 1999, last paragraph of my lord Justice Amitabh Roy's judgment. And if so, my lord, then that 4/2/2006 is a formal order by which the government took over. And the period from 2003 till, my lord, because till the whole period from 2003 was subsequently regularized. So, my lord, if we have a government service prior to 2005, my lord, we cannot be denied pension. And my lord has seen that ACP benefits were given to us considering the service from 2003.
Is for counting of seniority.
yes.
My lord, I'll only have one submission, my lord, in page 54, my lord.
It's
Page 54
54, my lord.
of that 54506.
Or 4506. Because my friend was saying that we became government servants only from 4/2/2006, my lord.
You're saying,
My lord, will have just one, this the letter. I am directed to say that the governor of Assam is pleased to. I'm directed to say that the governor 54, my lord. I'm directed to say that the governor of Assam is pleased to accord ex post facto approval for creation of 1 to 72 numbers of Gaon Panchayat Secretary under Panchayat and Rural Development here for the period rendered by the Gaon Panchayat Secretaries concerned from 35/2003 to 3/2/2006. The ex post facto creation of post is accorded in order to treat the services of so and so numbers of concerned as regular service against sanctioned post for the period 35/2003 to 2006. So, my lord, if I am now, by virtue of this order, otherwise also, my lord, I am there, but even by virtue of this order, I am a government servant from 3/2/2006, 35/2003, my lord. If I am a government servant already from 35/2003, because of the delay that was occasioning in your case, now you can't take advantage of that in passing these orders. And the judgment of my Lord Justice Ansari. My lord, page 43, part of para 3. My lord, that earlier round of litigation 829/2003, 1, 2, 3, fourth line, my lord, page 43. First paragraph.
Your parties there?
No, we were not, but similarly situated persons had come up, my lord. Some of these Gaon Panchayat secretaries came to this court by means of so and so by filing an affidavit in the said writ petition. Government took a stand that services of all the Gaon Panchayat secretary stood regularized on the basis of the letter dated 35/2003. Accordingly, the writ petition was allowed on 10/6/2003. Then, my lord, the second Assam State Pay Finance Commission is
recorded here. And my lord, second, Assam Finance Commission says these posts are there. And accordingly, my lord, the direction was, how do you consider this period? Because my lord, 2004 to 2006, we were not paid salaries, my lord. And that salary was dependent on the Finance Commission's report, my lord. In that view of the matter, because third Finance Commission had not come, so that period salary, if the third Finance Commission does not give us, how will, my lord, it be done? So the further direction was that this period, we count it, how you will count it for pension and pensionary benefit. Now, this is not required because, my lord, in page 54, they have already, from, my lord, 2003 onwards, they have given me a regular post and, my lord, they have regularized my services. In that view of the matter, my lord, sequence of events culminating in the 2018 order shows that I am a regular government servant holding a sanctioned post from 35-2003. Further, my lord, the ACP scheme I have already shown, my lord. Just refer to that. It says regular service. So they have considered that from 2003. I'm just showing, my lord, inferences here. That my service for all intent and purpose is from 2035-2003. The period before that, I'm not praying before my lord that my lord will also decide that period. That period, the government can, my lord, take a call under Rule 31 of the pension rules.
Salary and pension prior to 35-2003.
35, my lord, this is with the rider. My lord, I am covered by that Act of 1991, Division Bench Judgment. It will go, but still I am saying, my lord, that period, in the light of that judgment and the Act, the government can take a decision. That automatically comes in, but I'm not troubling your lordship with that. Let that government do that. But in the light of that division, or my lord Justice Amitav Roy's judgment and the Act of 1991. But from 2003, my lord, they cannot deny. This is my basic submission, my lord. So rest, my lord,
Where is the division bench judgment? Just
my lord will have. It was placed, my lord. I
no, it's
placed.
okay. Just
My lord, it would be paragraph.
just I marked that.
Lordship, my lord will just have that. My lord will have page 50 of that.
50.
50. The first paragraph. 1, 2, 3, 4, 5 lines from bottom. We are in therefore. First paragraph, my lord, page 50.
Should you which petition?
Oh, no, my lord, the judgment, internal page of the judgment.
It was given, a copy was furnished.
Oh, acha.
Copy was given.
Okay. The second file.
If the judgment, extra copy is in. Great petition, sir. My lord, item number 6, 4996, it is an next one.
4996.
4996. My lord has got it. Page 50, my lord. Sorry, page
Here it will be page 47.
47 onwards. My lord will come to page 75. What is 75?
Is 74 last time.
Page 74, my lord. Last 1, 2, 3, 4, 5 lines, my lord. 5 lines from bottom. 1, 2, 3,
No,
5, 6 lines from bottom. My lord has got it.
no, it's not here. It's not in 4996.
4996, it has been next.
Page 74, my lord, with petition.
Here, in the copy which is furnished to me, the last page is page 70.
That's the copy 9. My lord can have,
But just see this. I'm sending you back.
my lord can keep this one.
No, it's
But
okay.
only
No,
will
no,
excuse my
no,
noting.
not that, because Rate appeal 145 or 2009.
Fine. Yes, your lordship. That
Okay.
judgment, my lord will have that judgment date, internal page 23 of the judgment.
Just a moment. Just wait.
Page. Page 53.
This is judgment dated.
My lord dated 24/3/2010. 24/3/2010. Like there are 9.
Page 50.
My lord will have internal page 50 of the judgment. No, my lord. No. It would be here different. This is part of paragraph. My lord will come to paragraph page 74. It's continuation of paragraph 9. My lord, 5 lines from bottom, my lord.
We are therefore of the considered.
We are
view.
therefore of the considered view that benefit of provisions of this act, including those for pension and other retirement dues, would be available to the provincialized employee in service on or after 1/10/1991 on the basis of the length of their service reckoned from the dates of their initial. So the second pay commission report also says, my lord, that we were there and posts were there, but PRI posts. That was, and the SLP against this was dismissed, and my lord, they are all getting pensions. 354. Petition master.
Your lordship, the initial date of appointment, that means the against sanction post, your lordship. Without any post, how appointment can be made? Your lordship?
Is it correct? You please come to page 69 of that order. Page 69 is the cost title, right?
Which one? Yeah, my lord. Page 69, yes, man.
It's a past of it starts from page 54, serial
No,
number.
it's not, because it's a part of that order, man.
No, I understand.
Lordship.
That's what I'm saying. Page 54 says serial number, rate appeal, name, designation, appointment, date of retirement. Correct. So this is a part till 23.
Lordship.
Then page 24 is according to the retired employees above. Okay. So this is reference to that these people.
These people.
Okay.
And then, my lord, para 9, the honorable court, my lord, decides what is date of appointment, what is appointed day, and what does an employee mean. And therein, my lord would find at page 72, but that means page 26 of the judgment, down below, my lord.
Yes.
Employee means a person in the employment of the panchayat against a regular sanction post. Now, my lord would find the second pay commission report and the observations of my lord Justice Ansari in paragraph 6 at page 43, that they were already sanctioned posts, my lord. But those were PRI posts, and the act does not contemplate government posts. It is contemplating posts under the PRI. This is my humble submission, my lord. We are entitled to pension, and most of us are in the meantime retired, my lord. Our things have been kept on a hold.
This matters once again in on Monday.
Lordship, I'm
Because,
here. I'm here. Monday ki tarikh hai.
On Monday, Because-
29th, my lordship.
because in the meantime, I'll prepare it.
Lordship,
If there's any query, I'll come back.
lordship, I'll be here Monday. At 2 o'clock, my lord, at Monday. Or whenever it's
I don't-
convenient to your lordship. My lord, we'll listen,
I'm-
we'll make a mention, my lord.
The arguments, obviously, obviously you can add. Just like the argument in reply by Mr. You can add and the senior counsel for the petitioners. And Mr. K. Kaur, an additional advocate general for the state.
Your lordship, there is finance is also appearing also.
Oh, achha,
And put a PNR here.
along with Mr.
P. Handick, my lord.
P. Handick, learned government advocate, and Mr. R. Barbujari, learned study counsel for the finance department. You have anything more to say?
Some respect of them, I will hardly take 15 minutes, my lord. I can do it on Monday also, my lord.
No, you can, what you call, at 2 o'clock.
My lord, one thing I just missed out,
Hmm.
that 4996/2018. My lord would, there is a written argument submitted by my friend therein, written argument, wherein, my lord, at page 70, he has brought on record the consequential notification, my lord. Written argument, page 70. In pursuance to that writ appeal,
Just a minute. Written argument petition number,
my lord, 4996/2018.
yes,
My lord, in page 70, a notification is there of 17/3/2011,
of which date, 17?
3/2011,
Huh.
wherein, my lord, in terms of the division bench judgment in writ appeal 145/2009, the governor of Assam is pleased to order the benefit of provisions of Assam Panchayati Raj Provincialization Act, including those for pension and other due benefits applicable to state government employees, would be available for provincialized so and so who were in service on or before 1/10/96 on the basis of on or after 1/10/1991 on the basis of length of their service reckoned from the date of the initial appointment in the services of the panchayats. So that last 5 lines, my lord, of that paragraph, now, my lord, has been come as a obviously. This is my humble submission.
Lordship, just one submission.
Just add there one more line. This one 29/5/2023 for clarification, if any.
Lordship, in WPC 5123, item 7, I have taken the plea of promissory estoppel because based on the 2003 order, the petitioners have altered their positions from temporary employees to permanent employees
Just
under the
item number,
item number 7,
petition number.
5123. Last paragraph of my written argument, Lordship will find I have given reference to the,
5123 or 2018.
yes, Lord.
Your name?
MP Chaudhary. I have submitted a written argument also, Lordship. Therein, in the last paragraph, I have like quoted that the submissions that I am relying on to support my contention of promissory estoppel, Lordship. Right by all the.
You have altered your position as what?
From temporary employees to that of government employees government employees. So under the PRI institution, so the government is bound, Lordship, until and unless they show before your Lordship that there was some larger public interest that was there, they cannot alter from their promise, Lordship. And we are entitled to force that on the government, Lordship. And in that regards, I have relied on 2 Supreme Court judgments. I have quoted in my written argument, Lordship.
It come on Monday for clarification, if any.
On 29th, Your Lordship.
29th.
Lordship will be hearing me at 2.
Monday.
Clarification
Part 2, 2020. তোমার রাজি হবো না এইটা আছে সেম ৰবীন্দ্ৰ আজি ছোৱালী আনিব যাব নালাগে আজি মিছেছে আনিব নেকি অ আচ্ছা চলিলে
আচ্ছা ওকে 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 আচ্ছা আচ্ছা ও ও ও ও আমার মনে হয় সাতম পার্টনারশিপ একটা কন্টিনিউ হয়ে গেছে এখন কন্টিনিউ হবে বাড়ির পর যে সিরিজ চলি আছে 4 to 13 I know 4 to আমার আমার দেখা ব্যাংক অফ আমেরিকা আছে কেন আমার সিমিলার আমি এই যে আমাদের লাগা দেখবে হ্যাঁ kita beta ini kita beta educar que baca que as coisas আপনাদের কাছে কি আছে educar তাকে তো বেরে স্পেশাল কিছু আছে আমাদের মাত্র জিনিস ওকে ওকে আচ্ছা ওকে
Yeah, number. Final account full sangram full now. Financial.
ঠিকই আছে দাদা আমি ঠিকই আছে পয়সা দিয়ে দেবো দেখি বলে আমার কিছু আমি না পেনশন দিতে গিয়ে এবং না ঠিক আছে থ্যাংক ইউ দাদা
Yes.
Please, your lordship. My lord, I will be reversing the writ petition. My lord. That is, my lord, the All Assam Gaon Panchayat Secretary Association. That is the lead case, my lord, WPC 4506. Lordship may be pleased to take up 4506.
For finance, I have a different question
My lord.
in a lighter note, of course. You see, this entire episode initiated was because of, if you look at those relevant dates, earlier also I have said, then you'll come to know that everything happened near elections.
Yes.
Relevant dates in this case all relate to the announcement of elections. Correct. Now the question is, should we hurry and decide, or with passage of time, the government may change their opinion? If we come near elections, is there any possibility that there will be different opinion of the government?
Defending the finance department, my lord. Lordship, we are just in the status of a Mulimzi, my lord. We only take up the accounts issue and take up matters considering the financial health of the state. To that extent, my lord. Otherwise, my lord, so far as policy decisions are concerned, if it really affects, my lord, the financial conditions of the state, explicitly, my lord, under the rules of executive business of the state of Assam, in the insistence of the finance department, if a policy is taken, then definitely, my lord. I
No,
will
but you
be in a
see,
position-
at times you take different stands. Number one, if without your concurrence, the effect of this provincialization was given with effect from 20 2003. If that effect was given from an anterior date, you did not make any recommendation to prosecute those people who had created this situation. Mr. MP Chaudhary is saying that he is also claiming the principle of promissory estoppel. So if your officers have given that benefit,
So therefore, my lord, I will be relying on just provision of the constitution, the conduct of business of the government, Article 166. So it is already imbibed in the constitution, in my respectful submission, how the government is to conduct a business. Of course, my lord, if at some point of time, some government officials have taken a decision and that decision was circulated, and my lord, some actions were taken in pursuance of that decision, whether that can withstand the scrutiny of law.
is because the government did not disown it at any point of time.
In
This-
a democratic setup, my lord, the government may at many times, my lord, take decisions, my lord, because there are suggestions from all corners of the society, my lord, including, my lord, the treasury benches, the opposition
No,
benches.
you can't say that because of for two reasons. Number one, come to page 54.
My lord. Yes, my lord.
You read the first line that will give you an understanding of what I'm trying to say.
Yes.
First line.
Sanction of ex post facto creation of 1272 numbers of.
Next to it, the
Yes.
letter.
I am directed to say that the governor of Assam is pleased to accord ex post facto approval for creation of 1272 numbers of post of Gaon Panchayat Secretary under Panchayat and Rural Development Department for the period
So
rendered.
therefore, you see, it has the sanction of the governor of Assam. You
Yes.
can't just say that one officer has done it. He's not that one officer.
No, my lord, I am not disowning this. I will be disowning, my lord, the earlier, my lord, page 28 of the writ petition. Because that
28.
28, because this is the genesis and this is the foundation of the entire claim, my lord, of the writ petitioners. Page 28. This is the genesis, this is the foundation. Kindly see the, my lord, the tenor of this document.
Directed to convey the approval of the government.
Directed to approval of the government of Assam to regularize, but it is not in the name of the governor.
No, but the decision is not before us. This, I am directed to convey the approval
Yes,
that you have not produced the file and said that this approval was never there.
so approval, maybe, my lord, approval, my lord, it has to be in the name of the governor by means of that
That
notification.
document is withheld from us. So we can't make a comment, even if you disown it.
No, my lord, being or defending the finance department, my lord, I will be, my lord, submitting on these aspects of the matter because I am not representing the line department. I am.
No,
I
but
do not have
but
the
you see,
custody.
I am of the opinion, I don't know, I may be horribly wrong. But my opinion is that the government must speak in one language, one word, one mouth. If you have for your convenience unlimited numbers of offices, still you must speak in one language.
No, it is true, my lord, but at different points
No,
of
but
time.
you see,
my lord,
even you, being all powerful finance, you never called for this record and say that this approval was never there. Because you see, every department would be subservient to you because of the fact that finance is the one who will disburse the funds. So even if the smallest of your officer wanted this file to be scrutinized, even the commissioner of this or the chief secretary, additional chief secretary of this Panchayat Rural Development Department
yes, my
would not
lord.
have refused it. Even if your undersecretary or someone may lowest of the authority would have written, even the highest of the other department would not have refused.
Yes, my lord is looking from that view of the matter, my lord. I am, my lord, the last person to dispute it, but at the same time, my lord, it is my respectful submission, subject to my lord's consideration, my lord. That in view of Article 166, I will be relying on apex court decision also, my lord.
Okay, you make your presentation, whatever you want to.
My lord.
You make presentation as you want.
My lord, lordship, maybe please to, my lord, for a moment, come to page 24 of the writ petition. I will hardly take 10-15 minutes. So the prayer portion, my lord, what they are exactly claiming for, my lord.
Yes,
They are agreed, my lord, by the impugn notification dated 4/2/2006. And my lord, they are also agreed, my lord, by a part of the impugn notification. Communication, my lord, dated 28/3/2018. So far as, my lord, the aspect of bringing them within the fold of new pension scheme is concerned, my lord.
yes,
And then, my lord, they are harping on that 2003, my lord, communication, which my lord have just now perused, my lord. And finally, my lord, they are claiming their rights, my lord, under an office memorandum issued by the finance department, that is dated 9/6/2009. That, my lord, will find at page 25 of the writ petition, my lord, prayer numbers Roman 7. Prayer number Roman 7. They are relying on it. Similar benefits.
yes.
Now here, my lord, in this case, my lord, the finance department has filed a short affidavit only with regard to, my lord, that office memorandum of the year 2009. The stand taken by the finance department is that, my lord, the office memorandum is meant only for, my lord, workers and master roll workers. That OM, my lord, will find at page 50 of the writ petition.
page 50. Because the petitioners are claiming alternative reliefs one after another, but I will not term it as mutually destructive plea at this stage. But they are claiming very varied form of reliefs. And one of such relief claim is under this office memorandum.
Yes.
But at their perusal of page 50, that is the office memorandum of the finance department dated 9/6/2009. My lord, in my respectful submission would go to show that, my lord, this is meant only for workers and master role employees. It is not meant for any other category of employees. The petitioners have not identified themselves, or rather failed to establish before this honorable court that they stand on a similar footing with workers and master role employees. More so because of the fact that they are heavily relying upon, my lord, the Assam Panchayat Employees Provincialization Act 1999. When they are relying, my lord, they are claiming reliefs under their statute, under this particular statute. My lord, they could not have identified themselves as workers and master role employees and could not have claimed any under relief under this 2009 notification, which has been specifically negated, my lord, by the finance department in a short affidavit.
Yes.
Now, my lord, page 40 of the writ petition, that is the notification dated 4 February 2006. Page 40 of the writ petition, my lord, which is put to challenge herein, is a notification, my lord, in my respectful submission, issued in accordance with the provisions of Article 166 of the Constitution.
Just a moment.
My lord.
You are relying on this 2011 8 SEC 670.
No, my lord.
I'll be relying my lord on 2014 10 SCC 673 Gulf Goan Hotels. Where my lord Article 166 of the Constitution. Was
Okay.
there, I'll be placing that decision.
Against your submission, I have recorded 2011 8 SEC 670. State of Uttarakhand versus Sunil Kumar Vaish.
Yes, my lord. That also I'm relying my lord. So far as my lord Article 166 concerned.
Yes, what is the citation?
My lord. The present citation is my lord 2014 10 SCC 673.
Paragraphs.
My lord, I will be relying on paragraph, my lord. I have the Manupatra version, my lord. I will be relying on paragraph 17. Where my lord reference was made of my lord that Sunil Kumar Vaish. If my lord kindly permits me, may I read for a short while, my lord, Article 166. Conduct of the business of the government of a state. All executive action of the government of a state shall be expressed to be taken in the name of the governor. Orders and other instruments made and executed in the name of the governor shall be authenticated in such manner as may be specified in rules to be made by the governor. And the validity of an order or instrument which is so authenticated shall not be called in question on the ground that it is not an order or instrument made or executed by the governor. The governor shall make rules for the more convenient transaction of the business of the government of the state and for the allocation among ministers of the said business insofar as it is not business with respect to which the governor is by or under this constitution required to act in his discretion. Now, my lord, in Sunil Kumar Vaish, my lord, which my lord has just now referred to 2011 8 SCC, that was my lord relied upon my lord in by the Honorable Apex Court, my lord, in the 2014 10 SCC. That particular paragraph, my lord, paragraph 17, my lord, if I may read it, my lord. In absence of due authentication and promulgation of the guidelines, the contents thereof cannot be treated as an order of the government and would really represent an expression of opinion. In law, the said guidelines and its binding effect would be of no more than what was expressed by this court in State of Uttaranchal versus SK Vaish, reported in 2011 8 SCC 670 in the following paragraph. Now, in SK Vaish, my lord, it has been stated thus, my lord, held thus, it is settled law that all executive actions of the government of India and the government of a state are required to be taken in the name of the president or the governor of the state concerned, as the case may be. Article 77 and Article 166. Orders and other instruments made and executed in the name of the president or governor of a state, as the case may be, are required to be authenticated in the manner specified in the rules made by the president or the governor, as the case may be. In other words, unless an order is expressed in the name of the president or the governor and is authenticated in the manner prescribed by the rules, the same cannot be treated as an order on behalf of the government. A noting recorded in the file is merely a noting simpliciter and nothing more. It merely represents the expression of opinion by a particular individual. By no stretch of imagination, such noting can be treated as a decision of the government. Even if the competent authority records its opinion in the file on the merits of the matter under consideration, the same cannot be termed as a decision of the government unless it is sanctified and acted upon by issuing an order in accordance with Article 77 or Article 166. The noting in a file or even a decision gets culminated into an order affecting rights of the parties only when it is expressed in the name of the president or governor, as the case may be, and authenticated in the manner provided in Article 77 and Article 166. A noting or even a decision recorded in the file can always be reviewed, reversed, overruled, or overturned, and the court cannot take cognizance of the earlier noting or decision
for exercise of the power of judicial review,
Exactly, that is the point I'm raising.
my lord.
That decision was never overruled by anyone. That is the precise point. Because even if we accept that it was not an order
My lord.
of the competent authority, but it was never what you call taken back. That is number one. Now, if you come to you come to your affidavit.
My lord.
Affidavit by respondent number 7. Page 105. Because you come to your affidavit, this is not your stand that this orders were passed by persons having no authority and there's no.
It is not a pretext. It is not a pretext. It is my submission on the point of law,
No, you see, on a point of law also,
my lord.
there must be some essence so that the petitioner would,
Yes, yes.
would understand that this would be our argument, because you see, number one, if you don't deny the basic allegation and you don't assert the point you are trying to make in an affidavit, because you see, in one of the orders, I have dealt with this issue, and borrowing from one of the Supreme Court judgments, I have said that insofar as civil suit is concerned, there the manner of proof would be evidence led by the parties. But in a writ petition, the standard of evidence would be based on the pleadings made in the writ petition and as well as the affidavits.
There is no denial, my lord, not quarrel to it, but still I am my.
You see, because the issue is some officer somewhere must take some responsibility. He either says that X did not act in accordance with law, or he says that I don't accept the document because X did not do it in accordance with law. He can do both.
Yes.
He can point a finger on the concerned officer or question that document by tacitly referring to the officer. Incompetency must be brought to the notice of the court.
Yes.
So therefore, you see, the predicament, you love the chocolate, but then say that it's just like smoking. The government needs revenue, so they say that, well, we don't ban smoking, but smoking is injurious to health. Just like chocolates.
Right.
You say that it's bad for diabetes, but nobody questions that.
I'm trying to persuade my lord with only these aspects of the matter. If my lord takes cognizance, my lord, otherwise it is, my lord, I have to be fair to the court. It is not a part of my pleading. We have only dealt with, my lord, the 2009 notification explicitly stating that they don't come within the ambit of 2009 notification.
But the problem is that this is an order of 9/6/2009.
My lord.
So no, not that. This 4/2006.
Yes. 4/2006, and prior to that, my lord, it is 35/2003.
So either this officer who signed it is so heavyweight that people have out of sheer fear of that man, can't disclose his name. They can't question his signature, can't signature his order. And then after the 2006, now we are 18 years. Now, after 18 years, somebody has courage to say that 166 was not complied with.
I am trying to cling upon my on the provisions of law, nothing more, because I am not reversing their pleadings, my lord. I am just, my lord, trying to persuade my lord with whatever is there on before my lord on record. Only on the materials of record. Not any extraneous materials, my lord. So this is one
No,
of
the
my.
budget is something you'll have to create. Some freebies which are now being questioned everywhere has to be curtailed. Because some of the freebies are now compelling a lot of people not to work.
Yes.
So for the health of petitioners here, I think you'll have to start thinking for a budget.
Here precisely, my lord.
That's why I said, that's why I questioned. To you, I put a different question which was not put to either of them.
No, definitely. my
Will
lord.
something happen if we adjourn this, what do you call, this hearing to sometime near elections?
Then my lord may not require to be passed any order. Order will be passed otherwise also.
Okay, then I don't think anything else. Any more point, Mr.
Yes, my lord, one another aspect of my lord, the
Yes.
principle of res judicata applies here.
Principles of res judicata.
Yes, my lord. Because this 4/2/2006 notification,
Before that notification.
yes, my lord, this 4/2/2006 notification was already put to challenge by the writ petitioners in the earlier round of litigation before this honorable court. And that is a part of the pleading.
So this, even last time I think I told you, you see, the major difficulty in accepting that point would be Order 1 Rule 8. Order 1 Rule 8 CPC. Because if anything else fail, I come back to my original document.
Yes.
It makes me very easy to understand. Now you see, if it is a representative capacity litigation, somebody will have to take responsibility that this is a representative capacity litigation, and that the issue which was being determined, even the state did not take a plea that it would cover all the persons of that category. Now, let us take an example. The writ petition is qua the petitioners who are before the court. Now, whether that decision will bind somebody else who is not even born in the cadre,
Yes.
will it happen?
No.
Is it,
Yes, my lord, yes, precisely by application of section 11 of CPC, my lord, the parameters laid down may not be fulfilled. But here before, since it is a writ court, my lord, exercising extraordinary jurisdiction, I am making that submission. Strictly, my lord, because that writ petition was also filed by the association.
No.
It's-
Individual.
Well, it was by one Pranay Kumar Dev. But the fact that it was put to challenge and my lord, this honorable court has recorded findings.
No findings, no findings.
Strictly, my lord, I will have to be fair. Strictly, my lord, the records of section 11 CPC.
no, because you see, let us think it differently.
My lord,
Mr. Das.
is potentially, my lord, the third paragraph.
Yes.
With the regularization of services, with effect from 4/2/2006, as the petitioners happen to lose the salary period from 1/6/2003 to 30/3/2006, and they were also not receiving the benefit of the services rendered by them during this interim period for the purpose of computation of pension and pensionary benefits. The petitioners have impugned the notification dated 4/2/2006 in this week petition. Then finally, my lord, the coordinate bench have,
A better argument from you would have been issue estoppel.
my lord,
A better argument would have been issue estoppel. That an issue raised and decided
Would be.
would prevent the court from taking it up again on the ground of issue estoppel.
estoppel is always, my lord, a natural corollary, my lord.
No, it has, but this has to be specially pleaded.
Yes, my lord, it is again not there.
Issue estoppel is also something not,
Yes, yes.
we can just
Absolutely.
out of context and then decide that.
I am grateful, yes, my lord. No, my lord, absolutely correct. my lord. I cannot travel beyond my pleading, but still then, my lord, I am trying to persuade my lord with whatever is their admitted position on record.
Yes,
And then, my lord, they are claiming, my lord,
well, if had it not been you, as Mr. Professor is standing, I would have used a old English proverb. Yes, hitting a dead horse.
my lord, because
But since you are there, you don't you don't invite that criticism because of your overall what you call fairness.
no, my lord, I am grateful. But then again, my lord, no, depending the finance department, we also have to take care of bad debts also. Because bad debts is also, my lord, has to be shown in the accounts. One another.
Commercial litigation here, Mr. Tiwari would be more what you call appropriate. Yes,
And last, my lord, leave of my argument, my lord, with regard to whether the past services of the petitioners can be counted,
that is making a submission that we follow the government.
my lord.
That Mr. Nair is submitting that it will be the prerogative of the government to take a decision.
Yes,
He's
my
not insisting on that prayer now.
lord. Then, my lord, I will not be submitting. Because there are decisions, my lord, which I have brought, my lord. Otherwise, if it is not forthcoming from the petitioner side, my lord, I will not waste the.
Yes, consider that.
Yes,
But I don't know if Mr. Chaudhary and
if somebody is raising, my lord, then I will have to defend.
Continuous service with confirmation. From the date of our appointment, everything will be calculated.
so you are pressing that point.
We are held from 2003, we automatically come under 1969.
Okay,
No, my lord.
so that point they are not pressing.
No, if that is specifically left open by my lord, for giving a handle to the government to decide as to whether they would come within the ambit of new pension or OPS, my lord.
No, not that. For that, they are insisting on a decision of the court.
My lord,
Insofar as the past service is concerned,
my lord,
whether they would be entitled to that benefit or not, only that Mr. Nair is saying would be left to the government. Not
Past
the issue of,
service.
not the issue of pension. Only the past service prior to,
35/2003, in terms of my lord Justice Roy's judgment and the act. Let the government take a decision under 31. That much.
that is what his submission is.
true, but since they have made a specific prayer, my lord, that's why, my lord, it is imperative on my part, my
It's
lord.
okay, but that,
My lord,
that point
yes.
is not raising right
Yes,
now.
and my lord,
I just waste the time.
Hmm.
And this is not the first time I'm saying this, my lord. From the day I appeared in the matter, I'm saying this part, this court need not go into that dispute.
it is a.
But an observation would be required, my lord, that this is to be
As I am
considered.
concerned, I may have a short memory.
If
So
if my-
therefore, it is always better to have it clarified.
if my lord is relegating.
Not before your lordship, but even before other courts who had taken up this matter, my lord, I have made.
No, I'm not accusing you of anything. I'm just saying that whenever it comes to issues of short memory, it is better to have.
My lord, mine
Very
is shorter,
right.
my lord.
Huh?
Mine is shorter.
Is it after that, the now ban which has come in after that?
No, before that also.
Okay. Yes, this judgment is for what purpose?
Which, no, let my friend finish, I'll just place it.
Hmm.
My lord, I have not argued that we should be given the benefit of that work charge and the master roll that 2009. It is there in the pleading, but I have not pressed that before your lordship at any point of time. Now, my friend comes up and files an affidavit saying that that is solely for the purpose of work charge and employees. My lord, this is the notification at first page is the notification. There are a few teachers had come up before this honorable court. Stipended teachers saying that our past services is not being considered. Now, my lord would come to the last page, my lord. This honorable court passed certain judgments. The principal secretary finance applies that notification to the teachers, my lord, at the last page.
Which paragraph?
My lord will see the decision. Down below, my lord. Decision.
Yes.
In view of the findings, the petitioners, namely so-and-so, are allowed to get the benefits of pension and other retirement benefits under Assam Services Pension Rules 1969 with reference to OM dated 9/6/2009, subject to fulfilling conditions thereon. Subsequent order shall be issued by the administrative department after obtaining the PPNG department. So why this selective application, my lord? That's only I'm not even asking my lord to apply this, but these submissions have to take into account these actions also when the department is making that submission, my lord.
No, Mr. Bhattacharya is making that submission, not the department.
That's the
Department has
dangerous
already
thing
there.
happening, my lord. The submissions are self-submissions, not the department's instructions.
No.
Because the department's this action is this, my lord. I'm not asking my lord to apply that, but the department's action is this.
That department has taken a decision pursuant, my lord, to an adjudication of the facts of that particular case, my lord, where this honorable court has come to a definite finding that yes, they will be entitled under the old my lord, 1969.
No. This is they will be entitled under the
OM
services-
96/2009.
96/2009.
OM 96/2000. So
Give
thereby
him a copy, that otherwise he'll not understand.
OM 96/2009, it says, my lord, that the 1969 rules will be applicable to my lord.
No, see
Yes.
this order, last page,
Yes, my lord.
look at this order.
I'm
He has
not even
applied.
on the order. The order may be wrong, my lord. But why did you implement that? You could have gone up on appealing, is that? That order is wrong.
Last page, your departmental order.
Departmental order.
You have accepted this 9/6/2009
In a case of teachers,
for
stipend
teachers.
Although there is a judgment now that they are entitled, that's a
Yes,
principle.
my lord, opening line says the honorable this is in compliance of this judgment.
No, you're not getting the point.
My lord.
Point is simple. If your departmental stand is that this OM will not apply, but you have not gone in appeal insofar as that judgment is concerned. You have accepted it.
Yes, my lord, so far as stipendary teachers are concerned, therefore, my lord,
Okay.
I was about to place. Yes,
That stipendary master roll worker and
Yes.
stipendary teachers,
yes.
they may not be equal.
They may not be equal, but since this honorable court, my lord, has directed, so therefore, my lord, this OM has been applied in case of stipendary teachers. That is my submission, my lord. It is not my submission that per se this OM is applicable to them. I am submitting that, my lord.
Hmm.
Per se,
You see,
this OM is not
No,
applicable
but
to the,
once the department accepts a judgment,
my lord.
that means if the department have considered to that legal proposition, is it not?
Yes, my lord, that was with regard to stipendary teachers. There are other categories of teachers also, job teachers, access teachers, for whom, my lord, this honorable court, a coordinate bench has recently negated the claim. Only stipendary teachers, my lord, we are accepting.
The stipendary teachers by nature of the of their appointment,
Yes,
they are not master roll workers.
no, they are not master roll workers.
But
They are not
master roll
work charge
worker,
also.
master roll worker principle was applied there and
Ye-
it's been
yes.
accepted.
Yes, accepted the spirit of that OM has been applied
Not
there.
the spirit, the
Because-
OM has been adopted.
Yes, because there is no other OM. That OM has been, my lord, put to effect.
This is the dangerous thing that happens, my lord.
What dangerous thing, my lord?
When there are two phases of submission, one the departmental submission and one self-submission.
No, no.
This is what I'm facing trouble these days.
Lawyer, senior colleague may say anything, my lord. I am submitting only on the materials on record. I have not made a single statement before this court, my lord, which is outside beyond the record. That was it, my lord may then kindly, my lord. Take note of, my lord. Problem, my lord. My lord, this is, if my lord is having, my lord, SCC online. Lordship may kindly note, my lord, 2022.
Yes.
Yes, 2022 SCC online, ZAU 1165. Otherwise,
They were
my-
the parties.
yes, my lord, it is Purnima Hore, Purnima Hore, HORE. Purnima Hore was a state of Assam. Purnima Hore and others was a state of Assam and others. My lord, that lordship may also kindly record the repetition number, my lord. It is also, my lord, available in the website. That repetition is, my lord, 6403. 6403 of 2021. And the date of decision, my lord, 6403 of 2021. And the date of decision is, my lord, 31/3/2023. The coordinate bench has extensively dealt with, my lord, the issue of, my lord, old pension and new pension, how it is to be applied, everything. My lord, here also, my lord, finance department has from a time, my lord, for quite a past time, my lord, has granted the benefit of, my lord, old pension, my lord, benefits under the old pension under the rules of 1969 in case of stipendary teachers. Save and except stipendary teachers, my lord, no one has been given the benefit. And this is also precisely accorded by the coordinate bench, my lord. So therefore, I am not making any submissions before this honorable court.
Decision is not based on that
person
one of
in
2009. It's an independent decision. It's not based on the OM dated 2000.
So therefore, I am not making any submission before this honorable court in my personal capacity. Whatever I am submitting is, I am submitting on the basis of materials available on record. And it is right saying, my lord, that this honorable court is exercising its jurisdiction of a court of record.
You gave the citation 2022 SCC online 1165.
My lord.
Got
No. No.
It should be dated, my lord, may kindly, my lord, is 6403 of 2021, because I am having, my lord, the downloaded judgment from the
I
website.
don't know. I can show you this.
Ah,
SSC online also.
it's not on the
23 open the Guwahati.
Also, for that.
23. Citation. Citation to the month 23, 2023,
2022 SCC online,
23.
22.
Unto.
No, it can be 23 only. If the
23.
judgment is of 23, it can't be
23,
22.
it's the other one,
2 days,
1 and a half months once, 2 months.
Yes, yes. It could be 23. not that.
23 हो কি হরেছে
My lord.
পূর্ণিমা হবে I'll just give it them.
It was,
2023 SCC online Guwahati 1161.
Yes, my lord, I'm sorry, my lord, it's a 23.
Sorry.
oh, my 100 pages. sir.
By that common judgment, my lord, a series of matters was disposed of, my lord.
Just give me back my tab. Here this benefit was granted, whole pension.
Yes,
Was
full
granted
pencil
to
was-
my lord stipend teachers.
Only to the stipend, that's what I'm submitting,
But my lord, this judgment has got nothing to do. I also did not know, my lord, that earlier there was a decision of the government in terms of this 26/2009. That was never referred here. No? It was never brought in here. Independent of that, this decision had come.
Because my lord, that judgment has also taken.
It starts from, my
note
lord,
of-
stipendary teacher starts from para 22 onwards.
My lord, in between, my lord, in the year 2011, a statutory amendment has been brought, my lord, in the Assam Service Pension Rules, 1969. That has been dealt with, my lord, in that decision, my lord. That Purnima Hore. Because until and unless there is a challenge there to, my lord, to the statutory. rules.
You have to give me those paragraphs because downloading is again 100 pages downloading. I'm not
Yes,
prepared to do it.
Yes, my lord, I will be giving the paragraphs, my lord.
DD na download karo to game. My lord, the 22 to paragraph 37 my lord. Stipend teachers.
And there, my lord, the honorable court has dealt with, my lord, different categories of employees. So far as stipendary teachers are concerned, my lord, that my lord will find that, my lord, from paragraph 27 to paragraph 34.
SCC में
Downloaded.
down SCC
So Prabhuji, you also given the paragraph where they have dealt with this issue of new pension scheme.
It's in the, towards the starting part, madam. It's towards the starting part, it's there.
I'll just give that paragraph. So it's
Yes,
easier
sir.
for me.
Final. Lordship, you also take note of paragraph 85.
এটা লিখি দিবি না, so-
Just write it down because it will be difficult
Yes,
for
yes,
me to
my lord, my
recollect.
lord. Because one decision of the apex court has been, my lord, relied upon, that is State of Jammu Kashmir versus District Bar Association Bandipura. That is, my lord, 2017 3 SCC 410. Where, my lord, the apex court has held, my lord, the regularization cannot be retrospective.
Yes,
No doubt about it.
regulation is not a mode of
Not a mode of
Yes.
recruitment. Huh?
And our regularization is 2003. And you have from that day given us sanction post. And my lord, only one paragraph I like to just place and then I'll close my lord.
Okay.
My lord need not go into it. In paragraph 9 of my petition, my lord, there are pleadings to that effect from the Panchayat and Rural Development Department. Para 9, very nice said, once you have given me those posts from 35 to 2003, I'm regular for all intent and purposes, and the pension flows to me. And the Finance Department, in para 5, respond number 7, para 5 of their affidavit has not traversed that. Further, all those orders which were passed, wherein now 166, whether it is proper or not, has been brought into record, were given to the Finance Department, and orders have been marked to them, and there is no pleading on record that these orders never came to us. Because the last order, my lord, page 54 and 55.
Just
Lordship. Para 9 of my writ petition.
yes, okay.
And only one point, my lord, page 55. My lord will only note the last 4 lines, my lord. Last 2 lines. Page 54 starts at 54, page 55, 2 lines. This is conference of finance so and so white there ordinated, and as per decision of the cabinet, item number dated on 17/10. After this, my lord, once the regularization, but the posts have been sanctioned retrospectively, how can you take this decision now? Make these submissions now, my lord. This is my humble submission. Much obliged. Fine. This is my, nothing more, my lord. This is my, much of.
Please, your lordship. My lord, regarding item number 6, my lord, an IA has been filed, my lord, regarding correction of, my lord, in the cabin of writ petition, my lord. Date of retirement of, my lord, petitioner was wrongly written as, my lord. And the same, my lord, the affidavit, my lord, additional, my lord, IA, my lord, sorry, IA, my lord, IA,
4996.
my lord, 995, my lord, IA,
Okay.
my lord, in 4996 WBC number. My lord, kindly see please. Paragraph number 3 of the writ petition, my lord. Paragraph number 3. Petitioner number 4, my lord. Krishna Mohan Setri, my lord. In 6 column, my lord. Date of retirement written as, my lord, the 21/4/1993. It should be, my lord, 31/1/2017. my lord. Para 2 of my, lord, IA, my lord.
Yes, we allow this correction.
Hello?
This interrogative application, we allow that correction of name, spelling and date of retirement.
Date of retirement.
For Mr. M. No, Mr. Islam, you'll have to file an application for amendment of this amendment application. You see, statement made in para 2 is inconsistent with para 3. Now you are writing, is wrongly shown as Krishna Mohan Chetri instead of Krishna Mohan. And then in para 3 you write, this is Krishna motion, something else. What is right now? You have to amend your amendment application.
Krishna Mohan Chetri, madam.
Look at the spelling, all the spellings are wrong. It is inconsistent. Check the spelling of para 3. Para 2 is not same as para 3.
Krishna Mohan Chetri.
Spelling.
My lord.
Go by the spelling, not by the name.
KRISNAC.
Yes.
Mohan Chetri. Instead of Krishna.
Yes. Now see para 3, what you have written there.
Para 3, my lord, para 3. KRISHNA. Krishna. Krishna Mohan Chetri.
Prior to that, look at the spelling. When I am saying it is wrong, it is wrong.
My lord.
It can't be correct.
My lord.
What is the spelling? KHISNA. That is not there in para 2.
Krishna. Krishna Mohan Chetri.
I am not on Krishna. All the 4 names are Krishna. Look at the paragraph 3, spelling at, please check it. Write in a different page, then you will understand.
Krishna, KRISNAC. In my
It is-
petition.
No. When I am in the interlocutory application, I am not reading.
Sorry, man. I am a note, para 3, my lord. Krishna Mohan Chetri instead of KRISNAC. Mohan Chetri.
You read it, you understand.
My lord.
I have understood what I have to.
Krishna, sorry, my lord. Krishna is my lord.
Correct.
My lord.
It took so much of time to understand that.
My lord.
Okay, but you will have to file an application, fresh application. You have to do it because this is a mistake. You are saying nothing, next day you bring it to on Monday,
My lord.
another application. We'll permit you to withdraw this.
My lord. I will not do it.
Sam Islam and Council for the petitioner permitted to withdraw IAC will 995 of 2023 and to file a fresh interlocutory application. Okay. Process matter closed. Okay.
My lord. I'm so grateful. I knew like you. Fourteen to 18.
Yes, Mr.
I
Tiwari.
pray your lordship to take up item number 18, my lord. My lord, the basic, my lord, prayer of the petitioners are, my lord. They are holding, my lord, periodic pata land and kacha pata land. And the Karbi and Autonomous Council has taken an eviction right, my lord. So, my lord, these petitioners don't come within the preview of government house lands, my lord. As we have already annexed our documents and thereafter, my lord, after the order was passed by this honorable court, my lord, we have placed the document before the authority also for verification, madam. But thereafter till date, my lord, the respondents have not filed any affidavit to that effect. Only the respondent number 2, the deputy commissioner filed an affidavit, taking a stand that since the other party is taken up, since the autonomous council is there, so these land matters are not being taken up by the deputy commissioner, my lord. So my lord, my lord, I'll just take your lordship to page 24, my lord, of item number 18, my lord. Well, this is the type of.
Where is your, where is the impugned order?
No, my lord, notice was never served to us, my lord. Notice was never served to us, my lord. Well, the eviction drive was going on. Apprehending that, my lord, we immediately.
No, you
approached.
see, what I've understood from here that this land was being acquired for defense.
No, my lord. Earlier, at some point of time, it was they intended to do, but they did not take it, my lord. Because my patta, my lord, was issued in the year 2017, my lord. The periodic patta. I'll take a lordship to page 24, my lord, initially. This is my kacha patta, my lord. Down below, my lord, find 3/10/2017, my lord. Then thereafter, my lord, this is the type copy, my lord. At page 25, your lordship would find the vernacular, my lord.
Oh, what is your name?
Firoz Khan, my lord, the petitioner here.
Firoz Khan, you see the page 32,
Yes, my lord.
you have given an objection.
Yes, my lord, that is correct. Page 32, my lord, is correct, but that was in the year 2010. But thereafter, my lord, they did not acquire our land, my lord.
Where is that statement? This is something I missed about.
No, my lord,
In
that
your
statement-
reputation, where you have stated that
Yes,
this
yes,
land was
my
never acquired, where is that?
Yes, my lord, just take your lordship.
Something I missed.
My lord, para 5, page 7, my lord.
No communication is something else.
My lord,
The
page,
land was not acquired is a positive statement.
my lord, page 7, my lord, para 5, my lord. Later on, the said notices for land acquisition were withdrawn by the government.
7.
Page 7, para 5, my lord. In item number 18, my lord.
Page 7 doesn't have para.
Para 5, my lord.
Page 7 is had para 4 only.
Well, maybe there might be a mistake. My lord, I am reading, my lord. The petitioner begs to state that in the year 2010, my lord,
There was no communication.
the lands in dark number 13, 16, 17, 24, so and so, in annual pattern under so and so, Laurizan block number 3, Moja, in the district of Kabul, were sought to be acquired by the Indian Army for setting up establishment. Notices were given to the petitioner amongst the other persons. It is stated that they filed objection to the aforesaid land acquisition before the Deputy Commissioner Kabri Anglo. Later on, the said notice for land acquisition were withdrawn by the government.
You are reading para 5.
Yes.
I don't know. This is what I just see.
I'm extremely sorry. There has been a marking mistake in my case, my lord.
Okay.
Because my lord, by hand, my lord, it will be made as 5, my lord. It should be 4, my lord. It should be 4,
Okay.
my lord. Correct, my lord. This paragraph 4 will be, my lord. Later on, the state notices for acquisition, land acquisition were withdrawn by the government. Statement is there, my lord.
Yes, Mr. Today you have information.
But, page 32, Roman 1.
that is the, their objection, my lord, notice under section 5A. Annexure 3, 32 Roman A. And notice at, my lord,
We begin a category statement that it was withdrawn by the government.
31B, my lord, 31B, Annexure 2. That is the notice, my lord. Acquisition of land for defense purposes at Lahorijan.
Yes, but
Notice
this is
issued
that
by-
it is withdrawn.
My lord. Then lordship will annexure case number 8/92. Land is required for defense purposes, my lord. That has not yet been, my lord, completed, my lord, from 1992 due to various litigations, my lord. Due to various litigations, presently is also going on, my lord. And lordship may look into the order passed by this honorable court in this particular case on, my lord. 28/10, 2022, first order.
Yes,
My lord, all these things are there. My lord, last third paragraph. The petitioner on or before 7/2/2022 shall submit the relevant documents pertaining to a land under his occupation of village so and so under the Karbi Anglong Autonomous Council before the Joint Secretary, Deputy Secretary Revenue, obtaining necessary acknowledgement from the said authority. In the event of such submission of such land documents by the petitioner as directed above, the respondent KSC in its revenue branch shall verify the land documents and also make necessary site verification. And thereafter it shall submit its report before the court on the returnable date. The lordship will look into my instruction, my lord.
just tell me, what does it say?
In the instruction said that, my lord, revenue staff along with the police and paramilitary force went to the spot, my lord. They were not allowed to enter the villages, my lord. All these villages are occupied by the personnel, some personnel, my lord. So the police personnel also cannot enter the premises. So, my lord, we have fixed, my lord, another 2 dates, my lord. This is the notification we have issued yesterday, my lord. That we have fixed another 2 dates, my lord, so that they can submit their documents for verification, my lord, with a specific officer assigned to it, my lord. I'm giving to the petitioner also so that he can ask his client to, my lord, attend before the Deputy Secretary Revenue,
Recording my order,
my lord.
recording the order.
So that we can verify their land, periodic pata documents, my lord. Maximum periodic pata documents were found the fake documents, my lord. So we have fixed another date, my lord, by this notification, my lord.
Okay. That's right. Mr. A. Tiwari, London Council for the petitioner, has submitted that the land on which the petitioner is residing was sought to be acquired for the defense purpose, but the petitioners were informed, the petitioner was informed that their land acquisition proceedings were dropped. Next slide. In this regard, the Learned Counsel for the petitioner is referred to statement made in para 4 of WPC 496 of 2022. Next para. Mr. J. Sutia, Learned Standing Counsel for the Karbi Anglong Autonomous Council, has submitted that as per instructions received by him on by letter dated 23/2/2022, the land acquisition proceedings was initiated way back in the year 1992.
1992.
And
For defense purposes, and my lord, that determination of the compensation amount, my lord, under 2013 Act has also been made, my lord.
okay.
And we have sent it to the defense, my lord, for that purpose, my lord.
And by passage of time, the valuation of land compensation was also determined was also redetermined under the
Right
right to fair compensation.
Act to fair RFCCTL 2013 Act.
This is valid from 2013 Act and was sent to the defense authorities for payment. First off, however, it is submitted that due to various litigations and serious objections by the concerned villagers, even the land revenue staff along with the police personnel could not visit the land for physical verification. First off, it is submitted that various attempts to have the land physically verified had failed. And that lastly, by an order number KAAC, just right here, order dated 22/5/2023, the Karbi Anglong Autonomous Council, Department of Revenue has assigned various officials under the Diffu Revenue Circle for verification of the land of Lahorijan, LAHORIJAN, block number 3, within bracket Khan Basti, public Dudu colony in Borjan, BORJAN, Moza of Diffu Revenue Circle. And it is submitted that as per his instructions, the field verification, the date fixed for field verification is tomorrow. Is it? It is tomorrow.
After verification, they will recommend for taking further steps.
No,
against the-
the field verification date
They
is
will
fixed. Man.
complete this exercise within 2 days, my lord. It can be extended, my lord, till 25th, 24th, my lord also.
Okay. Requiring, requiring the completion of exercise within 2 days. Next paragraph. It is also submitted that despite the observations made by this court in order dated 28/1/2022, directing.
We had even this, my lord. In my contempt application is also pending, my lord. We have even this.
Where is that?
Well, in my contempt application, my lord. My lord.
Okay,
Case
then
number-
you write in this way. And the learned counsel for the petitioner submits that pursuant to order dated 28/1/2022, whereby the petitioner was directed to produce the relevant documents before the joint secretary of the deputy secretary to the Karbi Anglong Autonomous Council from our revenue department. The petitioner has submitted the same. And documents in regard is stated to have been submitted in the proceedings of
Contempt
which-
case number, my lord. 78, my lord, is there.
court case number 78, on case seat number 78 of
At page 15, my lord.
2022.
Annexure B.
Within bracket annexure B. Full stop. Next para. Be that as it may. In view of the stand taken by the petitioners as well as the Karbi Anglong Autonomous Council. And taking into note the projection that the land acquisition proceedings are though initiated in the year 1992 is still pending. The petitioner shall cooperate with the revenue officials of Caribbean Autonomous Council for verification of the land,
Site verification,
the site verification of the land.
that is the word.
Okay. First one. Next one. The Learned Standing Council for the Caribbean Autonomous Council shall produce
We file the
their
affidavit.
updated instructions and or to file their affidavit in opposition on the next date of listing. List on when?
We can file it Monday, next Monday we can file it, my lord. Sunday, my
Give
lord,
me-
I'm calling the joint secretary revenue, he is coming, my lord. We
Okay.
can file it on next Monday also.
Okay. List on 2/6/2023. Affidavit, if any, shall be filed at least 2 days prior to the next date of listing. Interim order passed list and extended till the next date of listing.
Keep your right.
In the content, we only say that this matter will be, release this matter on to both sides are represented, this one, so and so. Okay. Just also record his presence, CKS Barua, government advocate for deputy commissioner.
Land acquisition, what is the, my lord, stays, my lord, he can say better than.
Okay,
Whatever
Okay.
the deed, my lord, we have already determined the compensation amount, we have already sent to the Ministry of Defense, my lord. And what is the process, my lord, but lands were, my lord, occupied by the various persons, my lord, so they wants the unenclosed land, my lord, Defense Ministry.
The only thing is that was the beneficiary, the defense could have been made party in this case. Because one, the defense, the beneficiary in this case, defense could have been made party in this case, Lawson.
no, he's got no, what you call, no.
I
due
think
to
one of
this
the
then.
prayer is for compensation also. Wound up prayer
There's no compensation.
My lord, my thing is that if my
Product-
lands are acquired, my lord, if the government wants, my lord, I cannot stop them, my lord. If legally the government acquires the land, my lord, will get the compensation, nothing more than that. Because there, my lord, no bar can be there, my lord. If the government wants. But that the government has to place, since they say, at one go, they say, my lord, they have already sent it for fair compensation, they fixed. Then they know who is the person who is acquiring the land.
directly responded
on
to
their
provide
position
proper
also they
compensation
are
to the petitioner.
Pay the money, my lord.
And as to why return manuals be not issued, directing the respondent authorities to provide proper compensation to the petitioner and her tenants to all those who are.
No, you see, two things. Number one, I understand that when there is a redetermination, then the acquiring authority would have to be a party, correct? Now, in your case, there are two different, what do you call, tangents. Number one, first tangent is that the acquisition of 1992, it will be the government who will have to show that this, the preliminary notification, issued under 6 will still stand valid, correct? Because it
It's still there.
can be,
Yes.
it can be. It lapses under the 2013 Act.
Yes, Lordship, because yes, the 2013 Act has come, then the whole compensation thing will be. Yes,
No,
it will be raised.
you are not wrong. There's a limitation to that notification. Its validity goes under 2013 Act.
Lordship, as per the provision of the 2013 Act, Lordship.
I'll show you.
Yes.
Right to fair competition.
সেইটো যদি পইচাটো সেয়া নকৰে তেতিয়াহ'লে এইটো as per the new act of law. Yes. If the proceeding has started and I think Lordship, the amount has not been paid or then it has to be on the phrase act, Lordship.
No.
2013 Act.
You see, I'll show you. Land Acquisition Act. Land Acquisition, Land Acquisition. Hello, to land acquisition. I'll just give you this book. We'll come to the you see 14 and 24 of this act. In your case, you won't be able to show that there was a what you call social impact assessment was done, number one. And number two, under 14, it would have lapsed otherwise also. Correct. Correct. Now come to 24. 24 says that under certain circumstances, acquisition initiated under 1894 Act would lapse.
Yes.
Then, if it is lapsed, why you are entertaining this writ petition? The land was, he will resume the land without any interference.
26 we said. 24 to 7, 24, 14 to 7.
We'll close this writ petition, we'll debar your authorities to enter the land. If there is no land acquisition, why should he subject himself for verification?
Yes, madam.
Present case is relates to, my lord, eviction of unauthorized occupants, my lord. The claim of the petitioner is that they are the periodic patta holders, so their lands are required to be acquired. But those who are the unauthorized occupants, my lord, they are required to be evicted. So both the steps are clubbing together.
No, you see, this also I have my own way of thinking. You see, number one, it is the state who is saying that this land is to be acquired for defense purpose. Correct. And then you say on the same land, he is residing there as an unauthorized occupant.
My lord.
Two things are inconsistent.
My lord, but in practical, my lord, this area, my lord, where the Dimapur bypass is crossed, my lord, this area is called, my lord, Khan colony or Dudu colony, like that way, my lord. And this area, my lord, is the periodic patta holders are from earlier there. Now the occupants are there, they are unauthorizedly occupied, my lord. That land, my lord, there are various disputes are there, the government could not acquire it.
No. You see, your statement itself shows that the government cannot acquire it, means it is a private land.
My lord, some of the lands are private
Yes,
land.
okay, I understand. But
About
for those land,
3,000 so and so bighas land, my lord, these bighas lands are the private lands. And there is a dispute is going on between those, my lord, major portion of the land. And in those lands, my lord, there is a communication is going on between the government, between the, my lord, the council and the defense ministry. And we have already in persons the deputy commissioner direction, social impact report and new, my lord, compensation has been determined. And that has been, we have sent it to the ministry, my lord. But as the land is under the encroachment, my lord, so the defense is declined to take the loan as on date. So we are taking at that stage for eviction, my lord, for unauthorized settlers. In some cases, my lord, about 10 or 15 cases are there. In some cases, we have filed affidavit. And in those cases also, my lord, there is Assam battalion revenue is there, battalion commandant is there, that we have settled about 150 bighas. in that portion alone, they have acquired and we have filed the affidavit in those cases. Altogether about 15 or 16 cases are there in this particular area regarding all those issues, my lord. And it is pending since 1992, nothing for last, my lord, 20 year, 92 to
But
20 years.
if under 24, it has lapsed.
My lord, as per the Indo development, whatever my lord, just I recall it, my lord. Indo Development Authorities case, my lord, in the Supreme Court, they have, my lord, taken into consideration of the earlier act and new act, my lord. As far as I remember, my lord, that point has been dealt with by the Indo Development Authorities case regarding the land acquisition. And if the proceedings are going on like that way, my lord, in the earlier proceedings, then in that case, my lord, Supreme Court interpreted it like that way, my lord. When it will lapse and what is the requirement of like that way, my lord. At this moment, I don't have this particular case, my lord. Indo Development Authorities case, all this, my lord, land acquisition compensation case 213 and earlier act, my lord. Those were discussed, my lord. Indo Development Authorities case,
Indo development.
Indo Development Authorities case, my lord. Supreme Court decided, my lord, this issue, my lord.
How do you person to learn a market?
Question, I think.
You have to basically what to get to us.
You have to proceed into key stage of the discipline.
INDO. Indo.
Indoor, INDOR, Indo
Oh,
Development.
Indoor,
Authority.
acha, indoor, acha, okay.
Indoor,
Indoor. Ah, right.
Indo Development. Authority.
There was also a review in this matter. One was that Manohar Lal. After that, there was again a special bench constituted.
Really, because starting of a proceeding as part of the old act is not suffice was it if it doesn't pay the award or the possession of that land which doesn't take it.
No, under that old act, you'll have to give a preliminary notification, then it has to be a final notification. So there's nothing on record to show that these two notifications are there.
Section 5 notification.
Urgent acquisition.
Urgent. Section 5 notification.
So the urgency itself has gone. Correct. Here it says. Section 24 has retroactive operation with respect to acquisitions initiated under the Act 1984, but not completed by taking possession or paying compensation in spite of lapse of 5 years, and proceedings are kept pending due to lethargy of the officials.
Then
In such event, drastic consequences as contained in section 24(2) follows, and purposive, by applying purposive interpretation. This was held, para 151, 165, 166. It has lapsed for all purposes.
That's not been decided.
that's all.
But then why you are subjecting him to what investigation?
Like, regarding my lord, eviction of unauthorized occupant. Now my lord, this proceeding, this petition relates to my lord unauthorized eviction. Unauthorized
But what is the preliminary proof that it's a government land?
My lord, he has submitted a document, my lord, periodic patta, which is.
No, that is okay, but first of all, if you are issuing a notice under under
In this case,
18,
notice, my lord, in this particular case, my lord, 18-3 notice was not issued, I think. No notice was issued to him. He apprehends that he will be, my lord, evicted, my lord. On apprehension, he came before this court, my lord. At that time in 2021, my lord.
so
At
now,
that time, notice were issued of the sum of the unauthorized occupants, my lord, under Rule 18-3. They moved, my lord, before the High Court, and some of the persons, my lord, who has the period claim that they have the periodic patta, they also approached the High Court, my lord.
so now what do you want me to do?
My lord, that has already been lapsed, my lord. That eviction has already been carried out, my lord. That has been gone, my lord. Now, my lord,
In these cases, what do you want us to do?
my lord, it may be closed, my lord, that they have already periodic pattas until and unless, my lord, periodic patta is verified, and it is regarding that if it is not genuine also, then the cancellation of patta will come. Then we have to issue notice for cancellation of patta. Then we can only evict them. Otherwise, not, my lord. That is the legal, my lord, law, my lord, at this stage, my lord. And at only that we will file the affidavit. What is his, my lord, status of the, my lord, land periodic patta
Let
verification?
it be like that. Then.
Hmm.
You just record presence of Mr. C.K.S. Barua and say, no, this verification is done by Deputy Commissioner.
No, it is under my lord, deputy commissioner has no rule, my lord. Verification will be done by lord, as the, my lord, under paragraph 3, my lord. Land
you'll
is the,
do
my
it.
lord, subject, we can
Okay.
enact the law. We have enacted the law, my lord.
Then what is it, in the last line you write, on the next date? On the next date, the standing counsel for the Karbi Anglong Autonomous Council shall inform the court about the latest status of land verification.
Right.
That's the last part. Okay.
My lord,
List
we are-
on when?
We are given 2 days time, my lord.
2/6.
The notification I have seen, my lord, it expires today, my lord, because 22 it was issued for 2 days. my lord.
Lordship,
Please-
No, no, no,
please
no, no,
just take
no.
if you are given the time, my lord.
22, if it is issued, 1 day is excluded by under General Clauses Act.
Yes, my lord.
The date on which it is issued is always excluded.
My lord, last line says that they will complete the exercise within 2
if
days.
he undertakes, my lord, to be
2 days.
present, my lord, I can undertake that, my lord, he can be present on 25th also, my lord. I can take that, give the assurance. Yes.
Okay.
If he assures that tomorrow or day after tomorrow, he will appear before the Deputy Secretary Revenue, my lord.
Okay. Just saying. It may be recorded that that as per the notification, this is a notification on order.
Order.
That the order dated 22/5/2023 envisages 2 days time
For
for
verification.
verification. The learned counsel of the petitioner expresses inability to attend as 1 day has already expired.
From today, from another 2 days.
Most of- Accordingly, at the on a query of the court as to whether the authorities of Karbi Anglong Autonomous Council would extend the verification period by 2 days. The Learned Standing Counsel for the Karbi Anglong Autonomous Council submit that he will convey the
My lord,
desire of the court to the authorities
another 2 days.
and grant so that they can grant further 2 days time for verification. Full stop. Next, the
petitioner shall
the
cooperate.
gesture of the Learned Standing Counsel for the Karbi Anglong Autonomous Council is appreciated, and the authorities of the Revenue Department of Karbi Anglong Autonomous Council shall extend the time for verification of the land of the petitioner till 25/5/2023.
My lord. The petitioner shall cooperate.
Accordingly, the petitioner shall cooperate with the verification based on when.
2nd June, lordship.
Okay, so second.
Earlier date.
Second, sorry, what-
Also, directly go to the office of the deputy commissioner. Karbi Anglong Autonomous Council.
That
That would be better, my lord.
that will be able to guide
My
you.
lord,
I'm obliged, Lordship.
So in other matters, what have you done? Item 14 and others?
Same matter, sir.
Same.
correct. Yes, Malak, they are also having kacha pattas, Malak.
Okay.
The all four will go, Malak. The all four will go, Malak.
Okay.
Obliged,
Separate-
Lordship.
separate offers.
23 to 25.
Yes. Uh, in this regard, I got this. I'll just tell you your cases which have been argued, so that if something I missed out, please point it out. Mr. Laskar argued that the petitioner had submitted his first stage bid on 5/9/2021. Correct. And he was waiting to participate in the second stage of bidding. So please tell us if I am wrong anywhere, huh? Please inform me if I am wrong anywhere. Actually, if I am incorrect. He was waiting to participate in the second stage of bidding, which is live auction. But the petitioner did not receive any information about the live bidding. And therefore, he visited the office of DFO Karimganj on several occasions, did not get information. And therefore approached the court in the first state petition.
Yes.
And this court, by order dated 23/11/2021, directed that the authorities place the copy of evaluation of tender bid before the court. Now, the case in writ petition 6455, as the petitioner came to know during the pendency of 6210/2021 that the petitioner had not uploaded the digitally signed documents. He has approached this court by alleging that the minutes was prepared on extraneous considerations. And accordingly, this court, by order dated 6/12/2021, had directed that the settlement made in respect of the stone, that stone mineral unit 1 would be subject to outcome of the writ petition. Correct?
Yes,
Then comes 577 writ petition. Now, since this stone, this extraction unit was settled with the respondent number 5, the order number 73 dated 7/12/2021 has been challenged in this writ petition. And the petitioner is praying for a fresh e-auction of the mining permit. It's called mining permit or it's called contract?
Contract, mining contract.
Mining contract.
But in subject to correction, in 577, another issue was raised by the petitioner that while my lord settling, the provisions of my lord Assam Public Procurement Act.
That's there.
Yes, sir, that was
Okay,
there. That was the additional.
He,
Otherwise, my lord,
he's saying that to take proper action against respondent number 5 and 6 as per the provisions of 6(5) and 11(1) of the Assam Public Procurement Act 2017. Also, sorry, 25(1)(d) also. Three provisions has been invoked. Now, the submission of Mr. Laskar is that he has referred to various clauses of the tender document. And it was submitted that in the bid document. It is provided that in case of difference between the documents submitted electronically and digitally, the documents submitted physically shall prevail. We have also submitted that the presence of the petitioner was mandatory before opening of the bids as per Rule 9 of the Assam Public Procurement Rules, which was not done. Correct?
Yes, my lord.
You have also submitted that since you are not present, the opening of bids was illegal. And you have also submitted that the non-acceptance of your bid was not a material defect. That digital signature not made is not a material defect. And in this regard, you are referring to Rule 13(3) of the Assam Public Procurement
Yes,
Rules
yes.
2020, right? You are also saying that since the index was digitally signed, that would include all the documents which is included therein.
One file.
It's one file.
Yeah.
Then you are also submitting that as per Section 25 of the Procurement Act 2017, the reasons to exclude you should have been communicated,
Yes, my lord.
which was not done. Anything else which I have left out? This is what I have recorded.
Yes. Okay, it is one act, I have referred the act also, my lordship. It is Assam Public Procurement Act 2017. That is clause 21, exclusion of bids.
That I have recorded. Three sections you have referred to.
And instruction, my lordship, they have given instruction by the Amtron that I should follow the instruction. So I followed and I uploaded one PDF copy, my lordship, because there is no provision for uploading two copies. Only one compiled copy should be uploaded.
Which that, which page?
On page 141 and accepted. 41 and accepted.
141, in which rate petition?
In
6455.
no, that 577 of 2022.
577.
This is the last repetition. All the facts are stated in that last repetition.
Yes, which page?
Page 141.
141.
This is the instruction given by the Amtron. It has relevancy with the bidding documents also. In the bidding documents, it was instructed that it was given that the instruction of the Amtron should be followed. 141 and page 56, both the 141 and except 10. And this is connection with page 56, my lordship. Because in the bidding documents, it was instructed under schedule 2 that the bidder should follow the instruction of Amtron. So Amtron has given instruction to upload single PDF copy. That I did.
Okay.
Page 56.
The Advocate General submission was short, it's saying that all the documents are not digitally signed. And then
And then, my lord,
you are also saying that insofar as that by submitting the login details, it was possible for the petitioner to see all the information which contained in the online platform regarding the second stage of bidding. And you are also saying that the earnest money of 88,55,000 was refunded on 23/6/2022
By RTGS.
by RTGS, yes. And you are relying on the cases of National High Speed Rail Corporation and Jagdish Mandal. Anything else?
And my lord, we had also produced a letter from the Amtron, which said, my lord, that every document has to be signed, every page has to be digitally signed. It was clarified by Amtron. And also, my lord, at that occasion,
Is it a part of the affidavit? No, it's not.
it was later on, my lord, it was taken. So in affidavit, there's a whisper that he has to sign, my lord. Paragraph 4 in the affidavit, my lord.
Because that we can't take cognizance of that.
It was demonstrated
It
lordship
was,
on
my
that
lord,
day.
should be
No, no,
recalled.
that is okay. But this instructions is
instruction.
not a part of recording.
Perhaps, my lord, we had given the letter by hand that day.
Show it to me. I don't remember.
And my lord, another issue was addressed. Maybe not before lordship, this matter was since there are 3 petitions. This procurement policy, my lord, this procurement policy, my lord, issue has been raised, my lord. It was not applicable to us because since we are not procuring, we are selling off.
That I am.
Yes. Yes. One. Finally, well, my senior, well, Mr. Goswami,
Just wait.
man,
Which I don't remember going through this document of 612.
that's okay, my lord.
You see, I'll just like, let me ask you a question then. You try to do it. And tomorrow morning, tell us, you digitally sign a document. Correct. Then please try to compile it, compile two digitally signed document into one PDF. What happens?
Every page gets signed, my lord. Every page gets signed. Not only the one page, my lord, not the forwarding page. Every page there's a sign, my lord. It is repeated, my lord. It goes on, my lord.
Two documents
Yes, my lord. It
independently.
becomes a single PDF. Maybe, my lord, it's 50 documents. It will, my lord, it will go into one document, my lord. It will become one document, one single PDF, my lord. If we click, we scan, my lord, 3 pages, it will become a one file, my lord, and it will be signed, my lord.
Pages can be added also, removed also. In a, while making the PDF, pages can be added also, removed also.
Ultimately, my lord, nowhere
After
it
making
is
the PDF.
stated that each and every page should be digitally signed.
No, if two documents are digitally signed, can it be made into one document?
Yes,
Yes.
ma'am. One file, one file, ma'am. Lordship can call Mr. Anupam, I think our person to go when there's a high court, we find some problem with the e-courts. There is one person, my lord. We call him up.
I'll call him. I'll call him.
Normally, my lord, when we scan some document to send to somebody or we get instructions, my lord, normally there may be 78 pages. Yesterday I received, my lord, but it comes in one single file.
Okay, I'll check that.
And my lord, last, my senior, he had left this note. So he had also, my lord, relied upon Bharat Coking Coal, my lord, 2020-16 SEC.
Bharat Coking Coal.
Bharat Coking Coal Limited, my lord. 2020-16 SEC 759. There are 29 to 35. And my lord, last submission.
Coking Coal versus.
Coking Coal Limited, my lord, only that much is there, my lord.
Okay. What is the citation?
2020-16 SEC
2000?
20.
Yes.
16 SEC 759.
759.
And last was my lord one. 2020, again 16 SEC 489, my lord. Silpi Constructions. That's all.
Okay. And your submission is only that you have received a LOI of 7/12/2021 and you are doing the work. And we saw the demonstration on 7/12/2022. And your 4 officials were there. You recorded their
Yes.
name. Okay.
May I please add 2 things, Lordship? Lordship, welcome to page 50 of the read petition. Starts from page 49, instruction for submission of the bid letter. Schedule 1, format of technical bid. At page 50 last, serial number 8, Roman 8.
all the submitted documents must be digitally signed, otherwise it will lead to technical disqualification. This is a condition. And then lordship, page 51. Page 51 is a format of bid letter. A bid letter, everyone has to sign it. Paragraph 2. We have reviewed the terms of the bidding document and hereby unconditionally and irrevocably accept, agree, and acknowledge the terms thereof. In this manner, in paragraph 9A, 10, 11, 14, this type of declaration is there. So that digitally signature is required, it is already there. Every document has to be digitally signed. And requirement of PDF is that all documents should be made in one PDF, but all documents should be digitally signed. Hmm. 141 he referred, page 141. Every document should be compiled into a single PDF, but all documents should be signed.
Okay. Yes, Mr. Raskar, anything more?
My lord, my crux of my submission is that, my lord, nowhere each and every page of the bidding document of the should be digitally signed. Such an instruction was nowhere, my lordship. And when one compiled PDF copy is instructed, my lords, that PDF copy is one document, my lords, and each and every page is the part of the whole. I cannot deny a single page from that PDF copy when I signed a digital signature in that particular PDF copy, because I cannot delete a single page from that copy. It is not possible because all the pages are merged into one. A part of, I cannot scrape a portion of that PDF copy. My lord, that is correct for myself. Time to time, I approach the Honorable High Court, my lordship, because no information was provided. All the information I got from the Honorable High Court, my lordship, even the impugned minutes also, my lordship, I got from after filing of the writ petition. I got that copy, my lordship.
Okay.
Yes, okay.
I thought it would be better if I rehear because a lot of time has gone by. I try to do this within this week.
Lordship, I have submitted 2 decisions regarding that employer is the best person to decide whether the condition is mandatory or not. It is Air India, paragraph 7, and CCL, paragraph 48.
Air India, para 7.
Paragraph 7, Lordship.
And
CCL, it is paragraph 48.
okay. So, heard Mr. S.B. Laskar, counsel for the petitioner. Mr. D. Gogoi, learned standing counsel for the Forest Department. Mr. Das, you have anything more to say?
Just for 6 months.
Anything more to say?
That he alleges conflict of interest. I am one of the bidder. I have stated in my affidavit there is no conflict of interest with the resolution number 5. I have clarified that.
Mr. S.G. Purkar, and counsel for respondent number 5, and Mr. B.K. Das, and counsel for respondent number 6. The matter has been reheard. Arguments concluded, judgment reserved. I try to give it within this week. Look passage. No other matters in the board.
Deeply obliged.